All mentioning list to my court officer.
Lordship.
If SIR
Yes,
matter,
sir.
mention the SIR matter. It will
mention the matter but not appear in the list.
Lordship.
Have you contacted the court officer? Then
Lordship.
contact the court officer. There will be a date.
Lordship.
Automatically, I have already mentioned the date. You contact my court officer. Court officer mentioning the
Lordship.
diary. You take the date.
Your Lordship's endorsement is a precondition for having it listed. My court officer has said so. Lordship, have you a favor to us by seeing your Lordship's endorsement.
Because I am giving.
This matter was
Instead of wasting time here,
yes, yes.
I am taking the time in the chamber.
This matter was earlier, but not again of Lordship. So this may be
What is the matter?
premature release.
You are arguing the matter.
This matter was already in the list,
Correct. So what has happened?
but
Deleted.
now not in the list.
It is deleted from the list.
Yes, Lordship, deleted.
My lord,
You are mentioning list due to my court
my lord,
officer.
my lord, this is a leave.
Then it will be called mention. If the matter is not
My lord,
My lordship, may I mention?
Mentioning this matter, Lordship.
you give the mentioning list to my court officer. Give the mentioning list. Mentioning the urgency, I will see to that.
my lord,
The urgency.
my lord, this
But
is
you
a
have to mention the urgency. If there will no urgency, I will not allow to list the matter.
My lordship.
Ah. Ah. Okay, you mention it. It will be listed on 25th as a to be mentioned.
My lord, this is urgent.
May I?
My lordship want urgent matter. My lord, I am praying, my lord, to file this.
You are not even stitched now affidavit. How the leave can be granted? Only you put the clip.
कल 25 से पेंडिंग है
Documents are in my
नोटिस इशू हुआ सर रेट पिटीशन फाइल है और
And see, to file this and move this on short service, Lordship, the issue is very important. I'm doing dredging of the Rupnaran River, Lordship, which knows is prone to flooding. I require a road challan from both the executive engineer as also the West Bengal Mineral Development Corporation in order to take the material out and thereafter transport it. The excess material I get to sell it, and this is no cost to state, so it's free for the state. Now, Lordship, the challan is not being issued. This is why all the material I've dredged up is lying on the shore. Lordship knows with the onset of monsoons, my work is already coming to a halt. If by the
You will get the double bill if
but
that
what
will come
happen
again
is,
into
Lordship,
that river.
now there will be flooding because with the rains.
That's why I'm telling. If you're again it will come to the river, then again you will get the bill for.
No, Lordship, we will not because the state is paying nothing. We pay it at our cost. Only the excess material we get to sell. So we will not get any benefit. But it will cause widespread flooding. Lordship kindly permits us to move this day after tomorrow, Lordship.
What?
It's a very small. Only a challan is to be issued by the executive engineer.
There is no terms and condition in the contract.
Well, there is. That's all been violated, Lordship. We will show that. They are supposed to give it within a 30-day period that has expired on the 15th of June. They are supposed to have done it. We've written representations, no response.
Tender period is over.
Well, but within 30th of June, the existing challans will be over, and after that, work will completely come to a halt. If there is flooding and the material goes back in, then I am guilty of breach of contract, and there will be flooding in that area because it's prone to flooding. Lordship will kindly appreciate the fact that villages are along the shore in that entire stretch. It's one of the major rivers in the state, Lordship. Kindly will give us a 5-minute.
Lordship, kindly allow us.
Within 10 minutes.
Lordship, kindly allow us to file this.
You are not understanding the English. Yes.
My lord, this I have the last date is on 30th of June. My lord, I have been arbitrarily my work order has been arbitrarily cancelled by the University of Vishwabharati.
13 is over.
Lordship, that is 30th June is the last date. My lord,
30th or 13?
30th.
Yes.
30th of June. Lordship,
What
please allow.
submission? What is your grievance?
My work order has been arbitrarily cancelled, my lord. I have been asked to evacuate.
When it was cancelled?
On 18th of May, and I have been communicated on in the first week of June. I have made representation accordingly, and they haven't taken any step regarding to this. Is an urgent matter, my lord. 30th June, I have.
So what urgency you have prayed for? What is the interim order?
stay of the cancellation order
Stay
dated
of the
8
cancellation order can
See,
be passed.
and my lord, my work order, it is, we will be outstated from the precincts, my lord. Kindly, my lord, kindly allow us. Kindly, my lord.
28 crore.
My lord,
Your Lordship, with your Lordship permission,
urgent matter.
Lordship, I have filed one writ petition in April
Listed motion.
2025.
Twice give all the mentioning list to my court
My
officer.
matter
I
is
will.
unlisted motion.
May I mention a matter, Lordship?
Unlisted motion, madam.
Where is
My lord,
unlisted? Where is the unlisted file?
do-
Where is the file?
WPA 9591. So the matter is on the point of jurisdiction fixation. One act, BUDS Act, Banning of Unregulatory Depository Act, which was implemented in the year 2019. But Government of West Bengal has not fixed any jurisdiction where to try.
উনি বসার পর করবেন
And is lawless.
এই জন্য আমি অনলাইনে করতে জানি
This is very urgent matter for fixation of jurisdiction. Also, Government of
Where is your writ petition?
petition has
When you filed?
I filed in the month of March.
So,
May.
so you filed in the month of May. Now, what is the
So
urgency here?
this is a very urgent matter for fixation of jurisdiction only.
Hmm.
So that my main case, my main suit, this is criminal criminal case will be there.
What is your prayer, sir?
Prayer is the fixation where the matter will be tried.
So that is to be decided on merit only, not on the interim measure.
So there,
Can the court pass an order with regard to the jurisdiction in the interim?
all the opposite parties will play away. That is the reason. Because
Sir, first you are satisfied. You are telling that this court has to decide the jurisdiction of the court. Which court is having the jurisdiction? This is your prayer.
yes,
On that jurisdiction can be decided in the interim stage or after hearing the parties. Then, so what is the urgency? You filed it, it will be listed.
the liquidation, staying the Steel Authority of India from saving the liquidation process.
Lordship, may I have your kind permission to mention?
Already liquidation process is going on. That is the reason.
So there is no arbitration clause.
No.
There is no arbitration clause. If the liquidation is there, naturally there will be arbitration clause.
I am not the member. I am the non-member. They have taken.
I don't know, sir. I don't find anything.
They
Yes.
have taken.
Give the list.
Last Monday, that I mentioned this matter with urgency. My lord has fixed this matter at 7 of July. But my son's admission, I will not be in Kolkata. Kindly. 7th of July, these two matters have been fixed by because of my son's admission. But I will not be in Kolkata. Kindly participate.
So when you will be back?
I will be back on 9th.
Liquidation.
After 9th, kindly.
I am seeking leave.
May I have Lordship's permission to mention a matter, my lords?
Let it.
My lords, may I have Lordship's permission to mention?
May I have my lords?
Last week, but it was not included, very urgent. My lord, there's a notification that is taken out, removing me. It's a 7-year barred than the statutory period of limitation. They've taken a complaint, they've removed me as a professional deliberately.
Yes, call the list.
My lord,
My lords, may I have your kind permission to
My lord.
mention the matter? My lords, this is a matter where the writ petition has been filed against Competition
the
Commission
matter.
of India in February of 2026, my lords. Lordship, my right to file objection will be.
And I am seeking for
I
a
am
list.
only praying for listing this Wednesday, my lords. My lords,
Is in item number 1.
my lords, may I have your
Or withdraw the same matter, my lord, and liberty to file the press.
Why liberty?
My lord, 2 paragraphs are mistakenly typed in this petition, my lord. This is the instruction from the client, my lord. Paragraph 8 and 9.
The petition, the matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. The counsel for the petitioners submit that there are some mistakes in the writ application. As such, the petitioner has got the written instruction to withdraw this application with the liberty to file a fresh. in view of the submission made by the counsel for the petitioner, WPA number 12949 of 2022, withdrawn with the liberty to file a fresh.
Malad, may I have your kind permission to mention a matter, Malad? This is a writ petition against the Competition Commission of India. It was filed.
I am for the petition.
Yes.
But
Hmm. 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 Where is our affidavit? Where is the service? Where is the affidavit of service? You are appearing?
Yes, my lord, I am appearing.
Where is the affidavit of service? Where is the affidavit of service? You persons are mentioning when the matter is later, you are not ready with the affidavit of service. Yes, where is the show me the documents. Where is your application earlier? Which year you made an application? Hmm. 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 What is this? What is the page number 20? How the court can know where only one page has been disclosed? Where is what list is it is? We don't know. Where is the full list? Where is the letter? Where is the letter? Where is the contents? Whether it is a rejected list, whether it is approved list. I am asking one thing. You have disclosed one page of the list containing from 489 so. Well, whether this is a approved list, whether it is a rejected list, where is that? Where is the contents of this document? So how you got this? And how the court can rely upon this document? This is the approved list of the your name is appearing as the approved list of the old age pensioner. So you could have been taken out the web portal. Why you not taken the whole list? You are telling that it is available in the portal. Now you are telling that the officers provided you. The petitioner has filed the present.
May I be submitted one thing?
Yes.
My lord, on 29 January 2026, department has issued a report, my lord, kindly see. That was issued to the addresses of the previous advocate stated.
Have you given this?
No, my lord. I have only one copy, my lord. I shall give him within.
Who is Mr. Bipin Ghosh? State advocate.
Those advocates are previous panel advocates.
Correct.
Yes.
So it has not been served to the petitioner.
No, my lord.
So
Okay, my lord. I shall serve him.
serve the copy. You're having copy?
No, my lord. I just have one copy. I'll serve.
Get it, Xerox.
My lord.
The petitioner has, you go through the report. What the court is telling, the same thing is repeated in the report. That is not the approved list. The petitioner has filed the present application praying for the old age pension. Learned counsel for the petition submit that the respondent authorities have forwarded the report. He will serve the copy to the learned counsel for the petition in course of the day. The petitioner has liberty to take exception to the report, if any, within a period of 1 week from date. List the matter on 15th July 2026 under the same heading.
Macho.
Take the report from the
Yes, ma'am.
government advocate.
I'm party this.
Yes. Which department? You are appearing?
Yes, my lord. I am appearing, but brief was not allotted to me, my lord.
Yes.
Brief was not allotted to me, my lord.
Why it has not been, it has been served?
There is no allotment from the GP office, my lord.
On that day, GP came here and he assured that yes, all the matter will be allotted.
No allotment has been given.
The learned counsel petitioner has filed the affidavit of service. Let the same be kept with the record. Learned counsel for the state submit that she has not received the copy of the writ application. The petition is directed to serve the copy of the writ application along with the annexure to the learned advocate appearing for the state in course of the day. The state is directed to take instructions. Let the matter appear on 25th under the same heading within 10 matters.
Macho.
Next. Yes. Who is appearing? You are appearing?
Yes, my lord. Same thing, my lord.
Why? Very unfortunate state of affairs from the state.
This is difficult for us.
Which department? Fire service. Urgency. Okay, so the copy I am fixing on 24.
Yes, my lord. Yes, my lord.
Okay, what is the matter? Let me see. Yes. Driving training. Yes. Now, 101, what do you want to show? Okay. Yes. Yes. So what this is? No, contact. They are contract. Yes. Modular training simulator. Germany. When it was issued, contract was entered on when? 27 February. So when it is to be supplied? Yes. Where you are reading? Yes. Hmm. 118. Delivery start 27 February, completed by 26th August. One 121, what is this? Security deposit. Yes. First June. Yes. Buyer designation. Now, where from you reading 131? Which portion? Accept. Hmm. Yes. Cancellation. Now, who has sent this? Why? Cancellation reason: product service not required or particularly required as the result of which the buyer refused full or part of the product service or requested for discontinuation of the service during the contract. Product service not required. One 140. Same. Where are you getting the date? At the bottom of the page. Yes. You can ask for the steps like this. Yeah. Yes.
Yes. Yes.
Who has issued the tender? Gem. The petitioner has filed the present writ application challenging the term. It is not termination, cancellation. What did it say? A cancellation. Challenge the communication of the GEM authority, wherein the GEM authority attempting to cancel the tender issue in favor of the petitioner. The respondent number 2 has issued the tender notice through GEM portal for providing driving training simulator within bracket MHA bracket close within bracket V2 comma modular table / meeting table / center table within bracket V2 ventilation management training simulator, CNC simulator, multi-para monitor, that's low end, Terra package 1, there's robotic and automation modular skill kits, modular toilet, modular metal drawer, file, cabinet pedestal, augmented welding simulator, wooden shelf / case / rack / credenza / modular storage V2. The petitioner has participated in the set tender and a contact was entered with the petitioner on 27th of February 2026. This full list. The petitioner has to procure modular training simulator from Germany. And as per the said contract, the petitioner has placed the order. Placed the order. And the petitioner has requested the GEM authority for inspection of the said product. And in Germany. Police. In spite of receipt of the request made by the petitioner for inspection of the said product in Germany, instead of inspection, on 1st June 2026, 5th June 2026, and 8th June 2026, has sent email informing for acceptance of the cancellation of the request for supply of modular training simulator. Landed Council appearing for the petitioner submit that as per the contract, the petitioner has deposited the performance bank guarantee of rupees 67,67,500 and also invested an amount of 1,35,350. 1,35 or 1 crore? It is the 70 lakhs being the total being performance guarantee of 67 lakh and the total contract amount is 1,35,350. 13 crore. Acha, not point. 13 crore 53 lakhs 50,000. Full. Council for the petition submitted. The petition has made an arrangement with regard to the modular training simulator at Germany and accordingly requested the authorities for inspection of the same so that the petitioner can supply the said materials to the authority. But instead of inspection of the same, the authorities are trying to cancel the said tender. And Council for the petitioner further draw the attention of this court that the delivery, as per the contract, the delivery is to be started after 27th of February 2026 and delivery is to be completed by 26th of August 2026. He submit that the petitioner is trying to supply the materials within the contract period and as such the request and has made an arrangement for supply of the same from Germany and requested for inspection, but till date no inspection has been carried out, but by the impugned mail, the authorities are trying to cancel the tender. The petition has relied upon the judgment in the case of Subodh Kumar Singh Rathore versus Chief Executive Officer and others, reported in 2024, volume 15, SCC 461, and submit that this court under Article 226 of the Constitution of India can exercise the power under the contract for any under the contract if the authorities have acted with the ulterior motive. By referring this at judgment, common learned counsel for the petitioner submit that the contract period is up to the month of August 2026 and the petitioner is ready and willing to supply the materials and requested the authority for inspection, but without any reason and without any allegation of violation of any contract, the respondent authorities are trying to cancel the tender of the petition. But the learned counsel for the respondent submit that press for time to take instruction. Consider the submission made by the counsel for the respective parties, peruse the materials from report. This court find that the authorities have issued the tender for supply of the said material, and accordingly, as per the tender, as per the contract, petitioner has deposited the bank guarantee and made the material available, which is to be borrowed from Germany, and requested the authority for inspection of the said at Germany, but instead of inspection, the authorities are trying to cancel this said tender. Considering the above, this court find that the respondent authority without assigning any reason as trying to cancel the tender, though the tender period is up to month August 2026. Considering the above, this court find that the petitioner has made out a 5x case and balance of convenience and inconvenience in favor of the petitioner, and if at this stage an interim order is not granted, the petitioner will suffer irreparable loss and injury. Accordingly, the impugned notices dated 1st of June 2026, 5th of June 2026, and 10th of June 2020, 8th of June 2026, 8th of June and 12th of June 2026 are stayed for a period of 2 weeks from date. Full stop. The 2 weeks from date, the respondents are directed to file the report within a week after serving the copy to the land counsel for the petitioner. The petitioner's liberty to take exception to the said report, if any. List the matter. 29. List the matter on 3rd July under the same rule. ऊपर में affidavit of service capital तारीख. Next.
I am appearing on the behalf of state, my lord. We are trying to contact with department, but they are not picking up our call.
What is our request? What representation you made? Huh? When you made the representation after the Pradhan Mantri Awas Yojana you made, then that's correct. See, this is prior to the change of name. Where is the representations? How you are entitled to get the Awas Yojana benefit?
Section 3. And as per my scheme,
Hmm.
on the economic section,
Hmm.
they have no
Hmm. 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 Yes, madam. Affidavit of service filed by the petitioner be kept with the record. The
income certificate.
the grievance of the petitioner in the
Income
present
certificate.
application is that the petitioner is coming under the economic weaker section.
Economically
Police
weaker section মানে থাকে তো
The
income
government of West
certificate
Bengal launched a scheme
সেটাই আমি বলি
in the year 2010, namely Gitanjali for allotment of
they have not annexed any income certificate মানে whether they are the economically weaker section or not
you consider it. If you prove that, then you consider.
মানে
So what do you want? You want the flat? क्या बोल? Gitanjali. Full stop. In terms of the said scheme, the petitioner time and again made an application for grant of the said scheme, but till date, the responding authorities failed to consider request of the petitioner for grant of benefit of the said scheme. He further submitted. Now the name of the scheme has been changed to Pradhan Mantri Awas Yojana. Pradhan Mantri Awas Yojana. Though the name has been changed with regard to the scheme, but the terms and conditions are the same. He submitted that the petitioner fulfills the terms and conditions of the said scheme, but in spite of the same, the respondent authorities have not considered the request of the petitioner for grant of benefit of the said scheme. When the counsel appearing for the petitioner submitted, the petitioner has not disclosed the income certificate to prove that the petitioner is coming under the economic weaker section. Consider the submission made by the counsel for the respective parties, peruse the materials on record. This court find that the only grievance of the petitioner that the petitioner has made representation to the authority for grant of benefit of the scheme, now known as Pradhan Mantri Awas Yojana, and the same is pending before the authorities. In view of the above, the writ petition is disposed of by directing the respondent authorities, but particularly the respondent number. How many petitioners are there?
34 minor 34 petitioners minor
How many petitioners? How many stamps have been paid? No. You pay, then I will pass it. You come after 2 days. You pay and come. क्या बोला? Petitioners हो जाएगा. Particularly respondent number 5 to consider the representation of the petitioner by giving a opportunity, giving personal hearing to the petitioner, and if personal, and to dispose of the representation filed by the petitioner within a period of 6 weeks from the date of receipt of the summons. I will not sign. नहीं ना तुम sign. अगर कोर्ट फी देगा हमको उसका साथ ही फाइल भेजना. Next.
Item number 6, my lord, I am appearing on behalf of the state along with Mr. Loknath Chatterjee, Junior Standing Counsel. So, my lord, I just downloaded. I don't get my copy. I just downloaded this. So if your lordship fix 2 days only, I will give
Yes.
the instruction to the department and I will get the report so that I can place before your lordship what is what.
Yes. Learned counsel for the petitioner. Learned counsel for the respondents prays for time to take instruction. According cases urgent, let the matter appear on 25th under the same heading. Next. 25th.
20. 20.
Then come on 30th.
30th is okay.
Because 24 other matters are there, that's why. Under the same heading. Next.
7. My lord, I have done a mistake, my lord. I take this on me. That, my lord, I have challenged the tender with regard to, my lord, issuance of a tender to a third party. But my lord, third party has been left omitted from the array of respondents, my lord. My lord, may your lordship grant me leave to, my lord.
Leave and serve the copy.
Yes, my lord, kindly grants me leave to my advocate on records to have the third party be implemented as a party respondent.
The tender has been issued to the other party.
Yes, my lord. My challenge to that is with regard to, my lord, having him being disqualified in, my lord, the suit.
Learned counsel for the petitioner submit that. The petitioner has challenged the work order issued to the party concerned, but the concerned party has not been made party to the present date application. It is due to add the person in whose favor the work was awarded by the respondent. Accordingly, petition is given liberty to add the person who have been awarded the tender in course of the day, and to serve the notice to the added respondent and to file the affidavit of service on the next date fixed. This is the matter on how soon you file?
30th, my lord.
On 30th July,
So very great.
June under the same heading.
So very grateful.
Next.
Yes, Your Lordship. I am appearing, Your Lordship, in this matter. This is the writ petition for the premature release, Your Lordship. During the, Your Lordship, there is some development. During the pendency of this writ, Your Lordship, my premature has been decided rejected by the state, Your Lordship. Second, one co-accused has been released, main co-accused has been released by the Delhi High Court, Your Lordship, in this case. So I want to bring this development before this honorable court, Your Lordship. I seek the liberty of this honorable court to amend my writ petition, Your Lordship.
My lord, I have report, my lord. I have a report, my lord. Report.
When your premature release was rejected?
During the pendency, Your Lordship, this petition, my premature release is rejected, Your Lordship.
When? Date?
December. 11 December 2025.
2025, but the writ petition was filed in the 2026.
No, Lordship, recently I got the order, Your Lordship. During the pendency, my premature has been rejected. Which order I have, Your Lordship, I will produce it. Recently, it has been rejected very soon, Your Lordship, during the pendency of this writ petition, Your Lordship.
That's why when it was rejected. Because authority has submitted the report, your last rejection is March 2025.
I have been informed, Your Lordship, during the pendency of this writ petition, Your Lordship. That's why I am seeking the permission of this honorable court to amend my writ petition, Your Lordship. And apart from this
amendments like this, it cannot be. You have to file an application, sir. You have to file an application.
Supplementary affidavit.
Learned counsel for the petitioner prays for time to take appropriate step for amendment of the writ application due to the subsequent events after filing of the writ application. Learned counsel for the state has filed the report. Let the same be kept with the record. As per the prayer made by the counsel for the petitioner, case is returned with the liberty to take appropriate steps, if any, for amendment of the writ application.
Lordship, copy may please.
3 weeks from date.
Your Lordship.
Matter. Let them, after serving the copy to the learned counsel for the petition, state authorities, Release the matter on 23rd July. Next.
Obla issue. Obla issue.
Report may please begin. One copy of report.
Give the copy.
Malad.
Obla
Next.
issue.
I'm appearing on behalf of the petitioner.
Yes.
I'm being led by Mr. Shumaho Ghosh in this matter.
Huh?
I'm being led by Mr. Shumaho Ghosh in this matter. He's on leave before another court. I'm praying for a not today. We have filed our supplementary affidavit as per your lordship's order dated 16th April. The respondents have, the state has yet to file their affidavit.
What is the matter? What is the matter?
Lordship, you're not sure directed to file.
I am asking what is the matter?
Matter delays to.
Lordship, the council has present for pleading actually.
Land counsel for the petition prays for time. Let the matter appear on 15th July under the same matter. Next.
I appear for the petitioner.
Yes.
If my lord may kindly take can 9. This is my application for extension of the interim order. The interim order was first granted on the 24th of May 2024. This
What is the matter? What is the matter about?
This was in legal demand notice issued by the respondent bank. It was ex facie barred by limitation. It was a notice.
What is the demand?
My lord may kindly take the writ petition. My lord may kindly.
The state.
My lord, the bank.
Bank.
On the last occasion, the bank was represented by Mr. Shurjo Roy. He was just here, I am told, my lord.
Yes, where is the demand notice?
My lord, may kindly take page 38. My lord, may I just file my affidavit of service with respect to can 9, my lord. No affidavit is.
Yes.
Again. Let me kindly take page 38. Since my lord has a writ petition, may I invite my lord's attention to paragraph 18. My lord will find a list of dates there. I apologize.
Since 2024, you are only asking for the.
We are
only interim order.
We are ready.
You are appearing.
Yes, and
ready.
No, your lordship, because the affidavits are not yet complete. Give us the final and last chance, your lordship. If my client is not inclined to file affidavit,
let me hear it out. There has been no
Why
lacking on my.
persons are putting the burden upon the court if a bank is not interested to proceed matter? I am causing herein now. If you persons are not able to file the affidavit for 2024, they are enjoying the interim order.
You have given the draft to your lordship. The clients are not ready to sign it, your lordship.
No, lighter note, demand notice is time barred, affidavit in opposition also time barred.
The petitioner has filed the present application being can 9 of Canta 9 interim order. Why it is coming under the urgent motion? Why not coming under the application? That is also seen by this court.
There was a direction for it to appear under
Petitioner has filed the present application being can 9 of 2026, praying for extension of interim order. This court find that since the filing of the writ application, the petition is enjoying the interim order. In spite of several directions passed by this court, the bank failed to file the affidavit in opposition. Consider appearing for the respondent bank, submit that they have they have prepared the return statement and sent to the bank, but it has been returned back after the upload from the competent authority. Considering the above, the respondents are directed to file affidavit in opposition within 3 weeks, preemptory, failing which no further chance will be granted to file return statement. Reply, if any, thereto by within a period of 2 weeks thereafter. Release the matter on 5th of August 2026. The interim order is extended till 5th of August 2026 or until further order whichever. 5th of July. Pen number census. 5th of July.
5th of. I'm grateful, man.
Yes. Next.
Yes, my lord. I am on behalf of the petitioner.
My lord, before commencement of the hearing, my lord, I appear on behalf of the state respondent, my lord. I am praying before your lordship, my lord, sought accommodation, my lord. Also a direction upon the learned advocate for the petitioner to serve a copy of the application appraised, my lord, so that, my lord, we can take step and instruction in the meantime, my lord. Thereafter, by your lordship, consider the application.
What is the prayer?
My lord, actually, the petitioner number 1 is a JE qualified student. Her counseling is presently going on, and last date for document upload is 26 June 2026. And my lord, kindly see page number 40 of the writ petitioner. Kindly see, my lord.
Only paying sought accommodation.
Kindly see page number 40 of the writ petition.
40.
The the additional director and ex officio special secretary by memo number 459 dated verification and disposal of the application. Despite the said direction, the concerned authority is refusing to process the application solely because the pending SIR appeal of her father. Therefore, my lord, I most respectfully pray for a direction upon the respondent authority to process and issue the OBC certificate or within a time frame fixed by this honorable court.
Yes. So
kindly consider, your lordship.
What consideration?
Actually, kindly see page number 29, 30 and 31.
Now you have shown the 40.
Yes, my lord.
40, the district welfare officer written a letter to the additional director.
Yes, my lord.
Requesting to consider the application for verification of the caste and community status of the petitioner. Who is the petitioner here? Rebecca?
Rebecca Sami Ahmed, your lordship.
So what has happened to this? 3rd June?
Actually, Rebecca have a OBC certificate. Kindly see page number 29. Already have OBC certificate. Page 29.
Correct.
In the year 2020,
2014. Then it has not renewed.
At the time, renew. And she already applied for issuing a revalidation of OBC certificate for her admission in JE reservation quota. So, your lordship, we representation or legal notice to the concerned authority for a specific.
Your name is appearing in the voter list.
No, my lord.
So what is the prayer? Kindly come. That's why I'm asking. Kindly come to your prayer 1 and prayer B.
Petition number 2, voter, her father in voter list.
Kindly come to the page 2. Page 20, paragraph B.
Yes, my lord. I read or in the nature of fundaments comment the respondent number 11 and or the comment SIR appellant authority take up her and dispose of pending appeal. Petitioner number 2, your lordship. Petitioner number 2 is her father. There are 2 petitioner. Petitioner number 1 is a student. Petitioner number 2 is a father. Kindly see page number 32.
Petitioner number 1 is the daughter.
Yes.
Petitioner number 2 is the father.
Yes.
Your name is appearing in the voter list or your name is also deleted?
Actually, when I apply, kindly see page number 32. Page number 32. acknowledgement slip. When I applied 24 April 2026 for revalidation of my OBC certificate, then they are written below, document to be submit valid voter ID card of Sami Ahmed as per the latest order. Because in SIR, her father name is deleted.
That's why I'm asking.
Yes,
if
my
your
lord.
father's name has been deleted, so how the authority can revalidate your caste certificate? You have to first cross first bridge, then you have to go to the second
But
bridge.
her mother voter list is clear, your lordship.
First, the father has to clear. You have first the father has to clear. When the father is clear, then you have to go to the authority. Yes, you are belonging to the OBC category.
Actually, your lordship, appeal is pending before the SIR authority, your lordship.
So what do you want?
I want to direction to concerned authority to issue.
And how the
OBC
petition is maintainable? Your petition number 1 cause of action is different and petition number 2 cause of action is different. How the two different cause of action is came in a one writ application?
Actually,
how you included the two cause of action in one writ application of the two petitioners?
Actually, lordship, it is a fact, so I present before your lordship.
But you made prayer also.
Yes,
Fact you can narrate, but kindly come to the prayer 1, prayer B, A.
I also pray for obtain the is
correct. So
OBC
that's why
certificate,
both
your
the
lordship.
cause of action, both prayer you ask for.
Yes, your lordship.
Which prayer you want
Urgency
to express?
because your lordship kindly see 25th 6 June is uploading the document.
I appreciate
Her,
it. You are
her career, your lordship.
but your two cause of action, how the which prayer you want to press and which prayer you don't want to not press?
I pray for OBC obtain OBC certificate.
The OBC unless and until your father will be added in the voter list.
May I explain him? In terms of the Citizenship Act, in terms of the Citizenship Act, yeah, उनको पता है, sir. It is mandatory that the father or mother, either of them is a illegal immigrant, then the citizenship would not be granted.
Correct.
That's why they are harping upon getting the father's voter ID card.
Mother name is
Mother might be one father is father
Section
name
3
is
of the
deleted.
Citizenship
Once
Act.
father name is deleted, whether you commit treated is the citizenship. Then you have to prove the appellate authority has to clear that. Then if it is not, then the ministry will declare.
Any child born after 89 has to have a birth certificate, and both the parents have to be an Indian citizen. If somebody comes with a valid visa, they will be given citizenship,
One
not
thing,
with an illegal
do not
immigrant.
press the prayer A and C. I am allowing prayer B, directing the appellate tribunal to consider your where is the father's appeal? Have you disclosed here?
Yes, my lord.
Where is that?
Page number 56, your lordship.
Appeal against EPIC. Where is the appeal number?
Appeal number.
Yes. So I am disposing of this. So you not press. Both prayer cannot be granted in one writ petition, sir.
Lordship, kindly consider OBC certificate because her counseling
You
is
can
going.
file a separate writ petition after 2 weeks. Meantime, the tribunal will.
26.
So you have come late.
Document.
I done. If you want, I will dispose of this application directing to consider your ABC certificate.
Kindly consider.
But you will not get unless and until your father will clear from the voter list. Your father name is clear from the voter list. How you will get? Both the mother and father must be the Indian citizen. And your father's name has been deleted. Whether it is correctly or wrongly, or it has to be decided by the tribunal. Who is your senior?
Mr. Fazil Rahman.
You take instruction. First, you clear from the appellate authority. Once the appellate authority decided in your favor, immediately go to the authority for consideration of your OBC.
Okay, my lord.
Yes. What do you want?
Yes.
granting liberty to file afresh for other cause of action with regard to the SIR. His father's page 63 is the appeal detail.
SIR appeal consider, Your Lordship.
The petitioner has made
appeal to her.
the petitioner prays for not pressing prayer A and prayer C of the present writ application and is praying for and is pressing for prayer B with regard to disposal of the appeal filed by the petitioner number 2 before the SIR appellate tribunal, being appeal number APS 251-2G01042695018 dated 1st of April 2020. Consider the submission made by the counsel for the petitioner. This court find that being agreed with the deletion of the name of the petitioner number 2 in the voter list, the petitioner has preferred an appeal before the SIR appellate tribunal and the same is pending before the appellate tribunal. Considering the urgency pleaded by the petitioner, the SIR appellate tribunal is requested to consider the appeal filed by the petitioner number 2 dated 1st of April 2026 and to dispose of the same as early as possible. WPS dispose. Open affidavit service.
Kindly fix the time, Your Lordship.
As early you go, it will
Within 1 week, it will be.
Within one week.
Okay. Yes, next.
My Lord, I appear on behalf of the petitioner, my Lord. My Lord, the petitioner is a service provider or contractor. Petitioner is a service provider or contractor supplying the manpower to the different government offices. My Lord, in 2024, in a tender process, the tender notice was issued by the Akashvani Bhavan, Kolkata, All India Radio. My Lord, petitioner participated in the tender process, and my Lord, his status has been shown or displayed as disqualified. And due to administrative reason. And my Lord, page 29. My Lord, request has been declined due to administrative reason. No reason has been assigned in the display, and he submitted a representation and moved a writ application.
Where is that? Request has been declined due to the administrative reason.
Lord, see. Then, my Lord, he made a representation to the window, and my Lord, in the window of the website, JEM portal, Government Electronics portal, my Lord, page 30, my Lord, he moved a writ application before the.
Where is the tender notice?
Yes, my Lord, I have annexed the tender notice in 2024.
2024?
Yes, my Lord.
And when this order was passed?
Yes, my Lord.
When the page 29 was issued? Page 29 was issued when? What is the date of the page 29?
Status is disqualified.
When?
This is taken from the my Lord, their website.
When it was issued to you?
I find no date was there. It was displaying in their window.
Where is the tender notice? Show me the tender notice.
Then, my Lord,
September 2024. Correct. Where is the last date of tender?
Yes, my Lord, page 20 is the tender notice. Page 20.
Yes, 20. That is the dated 1st September, 11 September 2024.
Lord, and then, my Lord.
And the work was awarded?
No.
To whom it was awarded?
Moved a writ application, and the learned single bench of this honorable court passed an order. 29th October 2024, page 30. My Lord, this honorable court was directed to the respondent to consider the representation, and before consideration, opportunity of hearing would be offered. Nothing was there. My Lord, on the same date, my Lord, the Akashvani Bhavan finalized the tender in favor of another person. And my Lord, and they have communicated a decision. They have communicated a decision, page 31, 23rd October 2024.
This work order has already been issued.
This is a backdated letter. It was issued on the next date, that is 30th.
Whatever it may be, the October 2024, the work order has been issued.
Lordship.
Correct.
Lordship.
So now, what is the date of time of completion of the work? What is the time of completion? And you have made the party? The private respondent is a party
Yes,
here?
yes. No, there is no private respondent. I'm not challenging their selection because they have already finalized. I'm not challenging that. My lord, there is a communication, my lord, page 31. On the basis of recommendation of CAG audit, this office has forced to restrict your firm for participating any bid
through GM
or any other e-tender, as you and your sister concern participated in a bid in the year 2017-18 and secured a contract which violates the principles of GFR. My lord, the GFR never says so. GFR, no provisions has been quoted, my lord, and my lord, in 2025 also participated.
Yes, I am appealing on behalf of Union of India, led by Mr. Aurobindo Sheth. My lord, they have the lowest bidding.
Who is appearing for the Union of India?
Yes.
Deputy Director General, Headquarters, you are appearing for all?
Yes.
Yes.
My lord, I want to file the affidavit in opposition.
File.
Malays page 51 and 52. In 2025, I also participated, and they showed disqualified on the same ground, on the same reason. I'm challenging this order, page 52 and also 31, and also 31. In my right to application, my lord.
And counsel for the respondents press for time to file affidavit in opposition. Let affidavit in opposition filed within 3 weeks. Reply, if any, there to be filed within 2 weeks thereafter. Release the matter on 6th of August 2026. Next.
Thirteen.
So this is my application before you, Lordship.
Yes.
This is against animal slaughter before puja, which is this Manusha Puja, which is supposed to be held on the 30th of this month. This temple is run by Shivites. They took a resolution that from this year onwards, on Saturdays and any other days, including this Manusha Puja day, there will be no animal slaughter because of the fact that last year there were about 786 goats on a particular day, which is slaughtered. Now, after that, these people were pressurized, the Shivites. They were pressurized by the local, whatever, the people in power, including the villagers. Possibly, I'm not sure, but I was not a party to it. Possibly the resolution has again been overhauled or whatever. Now, the thing is that this slaughter is performed right in front of the public, open to public gaze, and somehow it violates the act and the rules. That is the main contention. And
what you have prayed for?
Yes, and we have made representation to the police. We have announced the resolution over the microphone throughout the villages, and there has been adverse repercussions. Now, my prayers are that we should not be sacrificing these animals on that day, or any other day, for that matter. Page 30.
Who are you?
I'm one of the Shivites, and also the treasurer of the committee. I am supported by quite a few judgments of this court. There is also, if I may hand up this public notice, this was on 13/5/2026, issued by the government of West Bengal, preventing animal slaughter, but it was the goats were exempted. Judgment was it. বইটা দে। Now, if your lordship kindly comes to this act and the rules, now, if your lordship kindly comes to the, can you reach that?
This is not with regard to the goats.
It's not.
This order which you relied upon, that is not the goats. This order is not with regard to the goats.
No, that's what I said in the.
Correct.
That's been exempt. Others.
Hmm.
Now, this is, if your lordship sees this, the Prevention of Cruelty to Animals, Slaughterhouse, Rules 2001. There has to be prescribed places for, and there has to be licenses issued for slaughter of animals. Of course, gives me the jitters because I love mutton, of course. Section 3. Section 3. Your lordship kindly. I'm sorry, I should have pointed that out. Rule 3. Rule 520.
Yes.
And then, if your lordship kindly comes, the West Bengal Animal Slaughter Control Act 1950. I'll be relying on sections 4 and 5.
Yes.
So, your lordship, this is very clear that there must be a certification that the animal has to be slaughtered. That's in the act.
Correct.
And there must be a prescribed place.
Correct.
Now, this mandir is not a prescribed place by any chance. 800 goats being slaughtered.
Who is appearing for the author in this? Mandir committee?
No, I want to stop this.
I am appearing, my lord, for the committee.
Yes.
Before he starts, just that control order, which I showed you, lordship. This particular provision had come up. This sort of an exemption had come up before the Supreme Court. This is reported. Let's take that. This year.
Yeah, 19.
Yeah,
Not
19.
not that.
No, it no. 1994. Roughly 5 SCR. 515. Ashutosh Lahiri and others. With it, Lordship will go to 521. Page 521. 521.
Yes.
Now, G on the right side. G.
Yes.
but that is not the position. It is well settled that an exceptional provision which seeks to avoid the operation of main thrust of the Act has to be strictly construed. In this connection, it is profitable to refer to the decisions of this court in the cases Union of India versus Wood Pulp Paper Limited, 1991-1 JT, SC 151, and Novopal India Limited. If any optional religious purpose enabling the Muslim to sacrifice a healthy cow on Bakri Eid day is made the subject matter of an exemption under sections 12 of the Act, then such exemption would be granted for a purpose which is not an essential one, and to that extent the exemption would be treated to have been lightly or cursorily granted. Such is not the scope and ambit of section 12. We must therefore hold that before the state can exercise the exemption power under section 12 in connection with slaughter of any healthy animal covered by the Act, it must be shown that such exception is necessary to be granted for subserving an essential religious, medicinal, or research purpose. If granting of such exemption is not essential or necessary for effectuating such a purpose, no such exemption can be granted so as to bypass the main thrust of the provisions of the Act. We therefore reject the contention of the learned counsel for the appellants that even for an optional religious purpose, exemption can be validly granted under section 12.
Yes.
Votes cannot be made an exemption. And then after that, if your lordship kindly comes to the next one. Page 523. Paragraph 11. We start from paragraph 11. That's at page 522. In view of this settled legal position, sorry a minute. In view of this legal position, it becomes obvious that if there is no essential right of a Muslim to insist on slaughter of healthy cows on Bakri Eid day, it cannot be a valid ground for exemption by the state under section 12, which would in turn enable slaughtering of such cows on Bakri Eid. The contention of learned counsel for the appellant that Article 25(1) of the Constitution deals with essential religious practices, while section 12 of the Act may cover even optional religious practices, is not acceptable. No such meaning can be assigned to such an exemption clause which seeks to whittle down and dilute the main provision of the Act, namely section 4, which is the very heart of the Act. If the appellant's contention is accepted, then the state can exempt from the operation of the Act the slaughter of healthy cows, even for non-essential religious, medicinal, or research purpose, as we have to give the same meaning to three purposes, namely religious, medicinal, or research purpose, as envisaged by section 12. It becomes obvious that if for fructifying any medicinal or religious research purpose, it is not necessary or essential to permit slaughter of healthy cows, then there would be no occasion for the state to invoke exemption power under section 12 of the Act for such purpose. Similarly, it has to be held that if it is not necessary or essential to permit slaughter of a healthy cow for any religious purpose, it would equally not be open to the state to invoke.
Yes, who is for the state? Yes, what is the rule
My lord, I have
with regard to the slaughtering of the goat?
Yes, my lord, I have contacted with the authorities, my lord.
Ah.
The authorities want to file a report.
But 24 is the day.
My lord, 1 day accommodation, my lord.
Come tomorrow with the report. What steps you have taken with regard to this?
Yes, my lord.
Yes.
I am for the authority, Milord.
Which
Milord,
authority?
Milord, respondent number 7, if your lordship sees, Milord, it's the Monosha Danga, Monosha Mondir, Shevayat Brindo.
Correct.
Milord, 5 points, Milord. First, Milord, the resolution, Milord. The resolution, Milord, which has been relied upon, Milord, by the petitioner in the instant writ petition, Milord, subject to correction, Milord, and to the best of my instruction and knowledge, Milord, that resolution, Milord, was superseded, Milord, by a subsequent resolution, Milord. Whereby, Milord, a decision was taken, Milord, that this year also, Milord, the religious slaughtering, Milord, will take place. First, that, my lord, your lordship will not find from the pleadings of the instant writ petition, my lord, but that will be evident, my lord, from one of the representations, my lord, which has been so annexed to the writ petition, my lord, at page 23, my lord.
So you are not sacrificing any animal.
We are sacrificing, my lord, because there has been a new resolution, my lord.
What new resolution?
The previous resolution, my lord,
when you taken the resolution?
my lord, that I need to file an opposition, my lord.
When is the your this puja?
24th, my lord.
So when you file affidavit in opposition?
My lord, my lord, then let me.
I am directing not to go. You file the affidavit in opposition. Next year you can sacrifice.
No, my lord, this year, my lord.
If you want to file affidavit, I will grant time, but I will restrict you for the sacrificing of the goat without in accordance with the law.
But the rules we are following, my lord.
That's why.
Let me just complete my submission. If lordship will just give me some time, my lord. First is the resolution, my lord. The earlier resolution, my lord, was superseded, my lord, by a subsequent resolution. Number one, my lord. Second, my lord, it's a customary practice, my lord. Your lordship knows much better than me, my lord. I need not delve much upon that, my lord. Third, my lord, the rules of 2001, my lord, which my learned senior, my lord, has placed heavy reliance upon, my lord. To the best of my instruction, knowledge, my lord, we are completely, my lord, abiding. In fact, the committee, my lord, is completely abiding, my lord, by the mandate of rules of 2001, my lord. Now, for the general public, my lord, the committee, my lord, cannot take responsibility, my lord. So far as the committee is concerned, my lord, stricto sensu, my lord, the committee, my lord, to the best of my instruction.
So how many goat the committee is going to sacrifice?
That I will take instruction and come back tomorrow, my lord, if your lordship so permits, my lord.
So I will not allow the public unless and until they follow the rule.
And second
rule, because your temple is the place for sacrifice, a notified place of sacrifice.
I am deeply obliged. Let me come back tomorrow. And fourthly, my lord, the order, the control order, subject to correction, my lord, the control order, my lord.
The control order, see, the court has to see, admittedly, you are going to sacrifice the large number of the gods.
I am deeply obliged.
At this temple. Correct.
I am deeply obliged.
Rightly or wrongly, whatever it is. But with regard to that, there are laws.
Definitely, my lord.
In India.
Definitely.
Which is covered in the state of.
Let me come back. Let me come back with my. Let me come back.
Come and you come tomorrow.
Yes, ma'am.
And just one last submission, my lord. The order, my lord, the control order which has been canvassed before your lordship, my lord, only subject to correction, my lord. I had checked it up, my lord. Perhaps male goats, my lord, are not covered by that control order.
That's why you come. If you are telling that, let the state also come, whether the state has granted permission or whether permission is not required.
I'll come back.
At any place, the goat can be sacrificed.
I will come back.
Or any number of the goat can be sacrificed.
I am deeply
and then the writ petition is to be discussed.
I am deeply obliged.
If you will not satisfied, then the court has to go by the law.
I am deeply obliged. I am deeply obliged.
When tomorrow,
Yes, ma'am.
I will not, because 24 is the next.
Yes, ma'am.
The learned counsel for the state as well as the private respondent pressed for a day's time to take instruction.
Just trying to.
Accordingly, both the parties are directed to file a short report by tomorrow after serving the copy to the learned counsel for the petitioner. List the matter tomorrow under the same heading within 10 matters. Affidavit of service be kept with the record. Keep the book tomorrow. Bring the book tomorrow.
Deeply obliged.
I am deeply obliged, my lord.
Come with the report.
Yes, ma'am.
And for the petition, my lord, earlier it was heard on 26/5/2026. Your lordship's direction to take information from insurance company. Here the petitioner purchased two policy bonds, annuity policy bonds, monthly income schemes. My lord, due to hard convinced by the bank manager and insurance and area manager of Kakinada branch. And thereafter, my lord, here the petitioner did not know about the facts and circumstances that the money cannot be withdrawn. Because he was very shocked due to his son's death, and this money was come from this death benefit of his sons, my lord. And thereafter, now the petitioner is seriously ill, his kidneys enlarged, and there are so many complications is arise, and thereafter he has no
house for living properly, and he contract with a promoter for purchasing a flat. Thereafter, she needs more money, my lord. Yes. Yes, ma'am.
Yes. But he has purchased two annuities. Both are single premium. One in 2021, the other in 2022. Not every month he is receiving rupees 15,105 for the first and the other 14,361. So that for the first policy he has received about 9,30,000, and the other policy he has received more than 7,30,000. Now Lordship kindly takes up the writ petition, the policy first. This is date 25th February 2021. Not here. Lordship kindly takes up this page. It is not numbered in my writ petition. Eta dekhao to kon page ta hobe? Eta kot number page hobe dekhao.
First policy 17.
Yes, page 17. Lordship kindly takes up
49.
First policy Lordship kindly takes up page 17. Now the date is 25th February 2021. Now this is to him, my lord. Lordship kindly takes up the bold portion. Please note that this is a single premium insurance policy. Lordship has seen that at page 17.
Where?
Page 17, Lordship. Yes. Dear Mr. Birendra Prasad Shaw, Lordship had got that.
Where from you are reading?
Eight koto page.
The policy holder.
This is the first policy. I first policy jate ki dekhacchi to. Eta kon page?
Second kotha dekhan.
Na na, I first page jate ki ready hoyechi. First page
15.
Yes, page 15, my lord.
Second আছে
আপনি দেননি কেন রিপিটিশনটা ঠিক মতো করে page 15 Lordship kindly takes up. Yes, Lordship had found the date on the right side at top, 25th February 2021. Yes, then dear Mr. Birendra Prasad Shaw, then Lordship kindly takes up the third line. Please note that is a single premium insurance policy. Yes, my lord, find that. Now Lordship kindly says the fourth column. Serial number 4, we enclose the following as part of the policy booklet. The policy document, first premium receipt, copy of proposal form signed by you, and copy of KYC and other documents. So that everything was forwarded to him at the very initial stage. Now that he had a period of free look period. If he was not satisfied with the terms and conditions of this policy, free look period. Yes, Lordship kindly takes up that.
Free look option must
Free
be
look option is there.
15 days.
Lordship, yes, 15 days.
30 days.
Internal page 5 of page 64.
Why not? You come to the 15 itself. Free option. Free look option.
Yes, free look option, free look provision. Lordship kindly says policy surrender. The third column you see, Lordship kindly says policy surrender not allowed under this plan. This was given to him. The policy surrender not allowed under this plan. Then Lordship has got this page, my lord. Then the exclusions, no exclusions. Then the free look provision. If you have, may I place the free look provision? Purchase the policy through distance marketing channel in 30 days from the date of receipt of this policy document to review its terms and conditions. For channel other than this distance marketing, you can review the terms and conditions of the policy within 50 days from the date of the receipt of the policy document. In case you disagree with these terms and conditions,
you paginate them, give them, then without the pagination, how the court can go through?
it's a proper repetition.
He is reading somewhere.
Pagination then.
Where is the pagination? I am dismissing here.
Yes, I have given the pagination, my lord.
Have you given the pagination?
Yes, my lord.
Yes.
ওই একটা পেজে দেখুন, একটা পেজও পেজিনেশন দেননি। আরে আমাকে তো দিতে হবে, আপনি আমাকে দেননি পেজিনেশন করে।
The petition has served the copy of the writ application along with the documents to the respondents, but the writ petition does not contain the pagination in the annexes. According to petition director to paginate the documents supplied to the respondent, let the matter appear day after tomorrow. Let the matter appear on 30th.
আপনি এটা নিন, নিয়ে দুটো মিলিয়ে নিয়ে দিন, এরকম করে মামলা হয় নাকি? আপনি ঠিক করে দেবেন।
I appear for the petitioner.
But I'm for the respondent. But I have received the reply, the affidavit reply.
We are out of time. Kindly extend the time to file the reply. We have served today morning, to my
Today, not morning, less 2 minutes back, I have received the reply. Lordship fixes any date for hearing, my lord, we'll come back ready.
Sometimes this week, my lord, perfect your lordship's convenience.
কালকে করবেন না স্যার।
And counsel for the petitioner has served the copy of
May I file it?
exception. File the copy. Exception or reply?
No, it's a reply to my
Affidavit reply after serving the copy to the land counsel for the respondents. Let the same be kept with the record. Counsel for the respondents prays for accommodation to go through the reply filed by the petitioner. According cases adjourned, let the matter appear on 25th.
Thursday. আছিস তো তোরা?
আগে তো 22
Very well, Thursday.
Same ID.
Grateful, my lord.
Yes.
Lordship, I am in custody since 1985.
1985.
I'm in custody since 1985. If your lordship may please see annexure P5, page 121, lordship. That's my detention certificate. My date of arrest was 11/3/1985.
125.
121, lordship. Annexure P5.
Yes.
My date of arrest is 11/3/1985, lordship. I have already got parole for 1 year, 8 months, 25 days without police escort, and there has been no adverse report against me. At this time, lordship, I am 72 years plus. If your lordship may please see annexure P3, page 90, lordship. My medical condition.
Just a minute. So you arrested on 11th of March 1985. Date of release not available, not applicable. The first sentence 31st of August 1992. You have been awarded sentence, death sentence.
Yes, lordship.
Awarded death sentence.
Yes, lordship.
Yes. Then
Lordship, later it was made to life, and I'm still in custody.
where is the life this commutation of life? Where is the order of the High Court? High Court or Supreme Court?
Supreme Court. Lordship, Supreme Court only had given me
Where is
life.
the High Court order? The death is commuted to the life.
Lordship, just a minute, lordship.
I have a report.
Barcode?
Paragraph number 4, my lord. There is a 66 meeting on August 2021, and the reason order is at page 6. My lord. It's 6 of the report, my lord. And one more thing, my lord, very recent meeting will be held on. That is the notification of the meeting.
Lordship, life, page 86, lordship.
Page?
86, lordship. Lordship, it's becoming a little hazy, lordship, because it's
The sentence was on Nasim for the offense 29 impose the next alternative imprisonment for life for the said offense, subject to the modification and dismiss. Yeah, life.
Lordship.
So that is, it is not the, this is a Supreme Court.
Yes, lordship.
Yes.
Lordship, even after the board had rejected, I had taken a detention from the correctional home, which clearly reflects, lordship, that my condition has been out of police escort. So there is no problem in society around. I am at the fag end of my life. I'm 72 years plus. Lordship, kindly, if you could see annexure P3, lordship, the page 90, lordship, the medical document. page 91 clearly shows, Lordship, that his condition of heart is not at all good. Even the correctional department is aware of it, that he is suffering.
Yes.
Lordship, also, Annex Chapter 7, page 135, that clearly shows a mass petition, Lordship, which states that while during this period of society at large have no problem, this is at the fag end of life, suffering, is ill, he's infirm. There is no chance, Lordship, that he can reoccur the crime at all.
Then?
Lordship, I humbly pray before you, Lordship, if this premature release could be considered by the board at this point, Lordship, with a detention which clearly reflects, including a satisfactory parole period, Lordship.
When the last parole was done, given to him.
Lordship, the last parole, file the call to. Lordship, the date is not mentioned, but just, Lordship, if you could give me a minute, Lordship. The Lordship, the last parole was this year, 2 months? 2 months back, Lordship, because he had visited me to my chamber, so I'm not sure about the date, Lordship, but it was last month only, without police escort, Lordship. He was very unwell. He's 72 plus, Lordship.
Yes. Where is the sessions judge order? Where is the trial court order?
Lordship, P1 order. Lordship, page 18. Sessions Judge at Alipur, Lordship.
Can you read this? You persons are filing the writ application without eligible copy.
Lordship, we have given.
Asking for the remission.
Lordship, we had given the type copy, but they also said the same, and this man's copy is totally out. All documents and everything are, Lordship.
You committed murder upon of the IPS officer.
Lordship, 40 years back.
Thinking that the IPS officer and IS officer will consider your case for the
Lordship, 40 years, Lordship. 40 years.
I am asking you.
Lordship, I think after 40
Where is
years.
the High Court order?
Lordship,
the Supreme Court order. The Supreme Court has commuted to the life. Where is the High Court order?
Criminal appeal does.
The petitioner murdered a young IPS officer.
That is 40 years back, Lordship. 40 years back. One of them is still in custody, Lordship. He was at the fag end of his life, Lordship.
Where is the High Court order?
Lordship, that High Court order we couldn't lay our hands on, Lordship.
Why?
Lordship, because he doesn't.
How the court can dispose of? The court has to see the judgment of the trial court, see the High Court and the Supreme Court, then other document, then the court has to come to some conclusion. If you are not having the High Court judgment, how the court can rely upon what the What is the observation of the High Court at the time of affirming the death sentence? That has to be taken into consideration. Where is that?
Lordship, actually we have tried, and since
Why
it's
the jail authority not having the High Court?
No, Lordship, they are not giving us that. Whatever has been given to us has
Why you are not applied for the certified copy from the High Court?
Did we apply? I think we did apply once. We did apply, Lordship.
When you apply, when the appeal was disposed of, where is the averments in the petition about the High Court?
Lordship, the High Court, we had no documents. We had only the document.
January, December, 1st December 1999. You have to leave of this court to produce the order and judgment of first term. So where is you are asking for the leave, but you are not producing. Kindly come to the page number 5, paragraph 6. Then you have never been on bail after the arrest. Where is the averment?
Lordship.
After the arrest, you are continuous in custody.
Yes, Lordship.
You are the under trial prisoner at the.
Yes, Lordship.
Where is that? Where is the averment?
Detention the worker. 1 minute, Lordship. Lordship, page 4. Petition. 3 and 4, Lordship. I've never been enlarged in the Lordship.
Yes, madam.
Yes, my lord.
What you will do with regard to the 45 years he has passed? 85.
My lord, the officers told me will reconsider.
What you will reconsider? Now the court, every time you are rejecting, what you will reconsider?
My lord, our next meeting will be held on within a week, my lord.
But how many meetings have been held and all the, because last meeting when it was held?
It was held on 5th of August 2021.
No. Last meeting
Last meeting.
of this petitioner.
21. Yes, my lord, 21. My lord.
Thereafter, no meeting was done.
No, my lord. Not for this petition, my lord. There are 40 others live convicts are there, my lord. I have placed, my lord, and the memo dated 11/6/2026, my lord. Kindly have a look.
Yes.
One memo dated 11. There is a this 40 live convicts are there, including this petition.
So when the meeting is fixed, have you any idea? Because 22nd June they are telling, but
it was fixed tomorrow, but it has been postponed.
So when it will be done?
My lord, within a week, my lord.
Then you will take. Then it has to be sent to the state. Then the state has to take the decision. Again, it will take the committee only recommend. Then the state ultimately decision is to be taken by the state.
Well, they have told 3 weeks they take time for a meeting, and after 3 weeks they file a report.
I am fixing, and today we are on 24nd. Come on 4th August. On 4th August, you take the file a supplementary affidavit with the report. If you considered, it's considered. If it's not, then the court will consider.
Lordship, a humble prayer before you, if a time could be fixed for this matter, because he's very ill, Lordship.
The Learned Counsel for the State has handed over the document dated 11th of June 2026, wherein it reveals that 40 live convicts are ready to place before the State Sentence Review Board for consideration of their premature release, including the petitioner here, including the name of the petitioner herein. It is submitted by the Land Council for the petitioner. The matter was fixed for the review meeting was fixed on 22nd of January on 21st of June 2026, but there could not be taken place, and it will be taken within 2 weeks. And thereafter, the same will be forwarded to the state authority, state government for taking appropriate steps. In view of the submission made by the council for the petitioner, as the state authorities are considering the case of the petitioner for premature release by holding the state sentence review board shortly. In view of the above, the case is adjourned. Let the matter appear on 4th of August 2026 under the same heading within 10 matters by the state authority director to file the report on the next date fixed with regard to the decision taken by the state government with regard to the premature release of the petition. Come with the report. If release it is okay, whatever it may be. Record karo. Dependency of this writ application will not prevent the state authority for taking the favorable decision in favor of the petition. Yes, next.
17, I am appearing for the petitioner. My lord, on the last occasion, the matter appeared on 6th of May, when your lordship has been pleased to direct to serve a notice to the bank. That has been done, they have received. My lord, very innocuous prayer. Loan was taken by my client.
What? Loan taken?
Loan was taken by my client, petitioner. Entire amount was, my lord, paid. Your lordship kindly comes to page 16. No due certificate was obtained. In spite of that, page 16, your lordship kindly comes.
Page 16, yes, I am there only.
My lord, yes. In spite of that, my lord, they are not returning me the original deed of conveyance, which was taken as mortgage. I have sent the representation that was received by them. Next page, page 17. On the last occasion also, in spite of service, they don't appear. That is the reason your lordship directed me. Status কিছু নেই। And on the last occasion, your lordship has been pleased to observe the order dated 6th of May 26 in paragraph 6. It is made clear that on the date fixed, if the bank failed to appear before this court in spite of having the knowledge of the hearing, the appropriate order will be passed in the absence of the bank.
Affidavit of service filed by the petitioner be kept in the record. In spite of service of notice, none appears on behalf of the respondent authority, appear on behalf of the bank. The grievance of the petitioner in the present date application. Grievance of the petitioner in the present date application that the petitioner has obtained loan of rupees 6,50,000 from UCO Bank Liluva branch, which was sanctioned on 29th of December 2025. 2025. The petitioner has relied upon the document appearing in page 16, annexer P2. Not considered by the petitioner submit that the petitioner has repaid the total loan amount of rupees 6,50,000, and there is no dues, and accordingly the bank has issued the no due certificate on 7th of August 2025, certifying that the petitioner availed a home loan of rupees 6,50,000 on 29th of December 2025 by reference account number 0532060130025, which was fully repaid and closed on 2nd of November 2022. 25 बोला ना 2005 होगा ना 2005 25 नहीं होगा full stop. As on date, the petitioner has no outstanding amount in the above mentioned loan account. The petitioner submitted at the time of obtaining loan, comma, the petitioner has kept the conveyance deed.
Yes, conveyance deed.
Conveyance deed in lien with the bank, but in spite of repayment of the total loan amount, comma, the bank has not returned the conveyance deed of the petitioner. The petitioner has made request to the bank authorities, but in spite of receipt of the request, the bank has not released the said original deed, conveyance deed to the petitioner. Consider the submission made by the counsel for the petition. This court finds that in spite of receipt of the notice, none appears on behalf of the bank. The only grievance of the petitioner that in spite of refund of the loan amount, comma, the bank has not released the conveyance deed of the petitioner in spite of several requests made by the petitioner. In view of the above, the respondent number 5 is directed to immediately release the sale deed being number 4676 dated. Why the deed dated? Why the deed dated 25?
My lord.
Why the deed dated 25?
Yes.
And you obtained the loan in 2005? Loan is dated 2005.
Yes.
Deed is 2025. How the 25 deed has
No,
come
no,
in?
no, no.
Yes.
The deed is, my lord, 2006. I have annexed the deed. Your lordship kindly comes to page 20. I made the representation on 26.
Sale deed number 4676 dated 20 March 2006 to the petitioner. If the deed is not required to any other loan amount of the petitioner within a period of 1 week from the date of receipt of the
Deeply
sale.
obliged. Deeply obliged.
WP is disposed of. Next.
My lord, I am appearing on behalf of the petitioner. My lord, kindly sees on last 28th of April, this matter was taken up, but
Yes.
there was no state respondent on that date. Hence, that matter was fixed for 18th.
Yes.
My lord, the petitioner's elder sister, she is the convict and she is in the custody for more than 14 years, 9 months.
What is the
And my lord, detention certificate I have annexed.
What is the sentence? 302?
Yes, 302, my lord.
Life.
Live. Honorable High Court, my lord, convicted her, and thereafter she went to Honorable Apex Court. There also, my lord, she did not get any order. Be that as it may, page 41 is a detention certificate, more than 14 years, 9 months. Our case is, my lord, firstly, she was sick. Initially, we preferred a writ application, but at that point of time, under section 433 capital A, she did not get the maturity for 14 years. Hence, my lord, we did not get any order. But the fact is, thereafter, she again preferred a representation on 22nd of November 2025. I have annexed in page 68. Our case is, my lord, her prayer has not been considered by SSRB. Till date, my lord, she did not appear before SSRB.
Yes.
Her prayer was not considered at all. She is the lady.
Her name is not in the 40 convicts.
She just completed the 14 years.
No,
9 months.
14 years, 9 months.
No, that 40.
Yes, my lord.
The last which you have ended over the order. Her name is there.
Yes, my lord.
Kaputi Banerjee.
Kaputi Banerjee. Yes, my lord. Her name is there.
Then, my lord, my humble prayer will be, can it be fixed for another date? In the meantime,
I am fixing on 4th of August. The other matter is already fixed.
Grateful, my lord.
It is submitted by the Learned Council for the state that the name of the petitioner is under consideration by the state review. What the state?
State review, sorry, State Sentence Review
State
Board.
Sentence Review Board. Review Board. In view of the submission made by the council for the state, the case is adjourned. Let the matter appear on 4th August बोल रहा था ना पहले वाला डेट कब दिया था पहले वाला last one when 4th August. Let the matter appear on 4th August by filing a report by the state authority.
Grateful, my
under
lord.
the same heading.
Grateful, my lord.
Next.
Lordship.
Same.
Same, Lordship. Now I'm in custody for more than 19 years. This is my fresh detention, Lordship.
His name is also there.
Yes, my lord. Already his name has been forwarded to the judicial department. Yes, my lord.
Then what has happened? Recommendation was made.
Yes, my lord.
So what has happened?
My lord, I have filed a report. Can you kindly see page number 8, my lord?
Page number 8.
Yes.
Now further regard to where is the recommendation? What is the name?
My lord. Let's see.
His behavior decent during regression, considering the long satisfactory.
26, paragraph 17, my lord. Dhananjay
His
Shi.
permanent release are recommended by the members of the board. So now it is pending before the
Judicial department, my lord.
since February. Learned Counsel for the State has filed the report wherein it reveals that the case of the petition for premature release is taken up by the State Sentence Review State Sentence Review Board on its 75th meeting on 11th of December 2025, and the case of the petitioner was recommended for his premature release. After the decision taken by the State Sentence Review Board, the matter was referred to the state government of West Bengal, to the government, and the same is pending for taking appropriate decision in terms of the recommendation made by the board. Full stop. In view of the above, the case is adjourned. Let the how soon it will take the 2 weeks, 3 weeks. Let the matter appear on 22nd of July 2026 for filing.
They have prayed for 1 month.
Wait, 22nd I am fixing. 22nd of July 2026 for filing report by the state.
Lordship, just to keep in record, if I could get a copy of the recommended. And Lordship, also one of his case partner was released by this Honorable High Court.
That's why, because under consideration. If it is not, then I will see to that. Let the report come.
Grateful.
That's why all I am keeping. If the report come, if it rejected, then the judicial order is to be passed. If they will release, there is no problem. Yes, next.
Grateful, Your Lordship.
Yes, my lord, I appear for the petition. I appear for the petition. My lord, in this matter, my lord, what we have challenged, my lord, is, my lord, a purported act of registration, my lord. Our contention is, my lord, the registration done by the registering authority concerned, my lord, has been done in violation of the, my lord, sections of the Registration Act itself. Now, my lord, the facts.
Registration of the deed.
Registration of the deed.
So how you challenge in the?
Yes, my lord. I'll address. My lord, this is the precise question, my lord, which came up before, my lord, Justice Shompa Sarkar as well. My lord, we answered the question. The matter is also pending hearing now. The affidavits are exchanged. My lord, question of maintainability, my lord, I'll address. Now, my lord, so far as, my lord, my lord, I am challenging here, my lord, the action taken by the registering authority. My lord, certain powers have been granted to the registering authority to, my lord, do certain things in a certain manner. My lord, my respectful contention before this honorable court is, my lord, those, my lord, actions have not been taken by the registering authority, and my lord, that is why we are before the writ court, not before the civil court, on so far as, my lord, that part is concerned. Now, my lord, this precise question, my lord, came up before the honorable Supreme Court in, my lord, the judgment of, my lord, asset reconstruction of 2022. My lord, this is very vital so far as, my lord, the maintainability. So, my lord, I am pressing it right now to, my lord, address your lordship. My lord, kindly, before, my lord, the facts are very simple. My lord, someone has, my lord, I say, my lord, someone has claimed himself to be the power of attorney holder on my behalf and sold the property to a third person. And, my lord, this is emanating from inaction or non-action by the registering authority, because had they properly followed the mandate of the statute, this would not have come to be. So, my lord, there, my lord, I join, my lord, the issue. Now, my lord, kindly takes the trouble of taking paragraph 53 of that judgment. Well, this is, I'll cite the judgment for my learned friend. Yes. Achha. Well, 2022, volume 8, SCC, page 210. Kindly, my lord, takes the trouble to come to page 235 of the report.
52?
53, my lord. Para 53, page 235 of the report.
Yes.
Yes. Now, my lord, fairly at the top, my lord, I'll placing it, my lord. Actually, the registration of a document comprises of three essential steps, among others. They are: 1. Execution of the document by the executant, signing or affixing his left hand thumb impression. 2. Presenting the document for registration and admitting to the registering authority the execution of such document. And 3. The act of registration of the document. Now, my lord, kindly sees, my lord, these are very vital paragraphs, my lord. 54. My lord, I'll place it because, my lord, lordship, I know, my lord, this question would come. In cases where a suit for title is filed with or without the relief of declaration that the registered document is null and void, what gets challenged is a combination of all the aforesaid three steps in the process of execution and registration. The first of the aforesaid three steps may be challenged in a suit for declaration that the registered document is null and void, either on the ground that the executant did not have the valid title to pass on, or on the ground that what was found in the document was not the signature of the executant, or on the ground that the signature of the executant was obtained by fraud, coercion, etc. The second step of presentation of the document and admitting the execution of the same may also be challenged on the very same grounds herein above stated. Such objections to the final and second of the aforesaid three steps are substantial, and they strike at the very root of creation of the document. The challenge to the very execution of a document is a challenge to its very DNA, and any defect or illegality on execution is congenital in nature. Therefore, such a challenge by its very nature has to be made only before the civil court, and certainly not before the writ court. The third step, next paragraph, my lord, namely the act of registration, is something that the registering authority is called upon to do statutorily, while the executant of the document and the person claiming under the document are the only actors involved in the first two steps. The registering officer is the actor in the third step. Apart from the third step, which is wholly in the domain of the registering authority, he may also have a role to play in the second step when the document is presented for registration and the execution thereof is admitted. The role that is assigned to the registrar in the second step is that of the verification of the identity of the person presenting the document for registration. Thus, the first two steps, para 56, the first two steps in the process of registration are substantial in nature, while the parties to the documents playing role of the lead actors and the registering authority playing a guest role in the second step. The third step is procedural in nature, where the registering authority is the lead actor. Number 57, my lord, next page. In suits for declaration and title and or suits for declaration that a registered document is null and void, all the aforesaid three steps which comprise the entire process of execution and registration come under challenge. If a party questions the very execution of the document or right on title of the person to execute the document and present it for registration, his remedy will only be to go to the civil court. My lord, this is vital. But where a party questions only the failure of the registering authority to perform his statutory duties in the course of the third step, it cannot be said that the jurisdiction of the High Court under Article 226 stands completely ousted. This is for the reason that the writ jurisdiction of the High Court is to ensure that statutory authorities perform their duties within the bounds of law. Now, my lord, 58 and 57, my lord, are also important. It must be noted that when a High Court in exercise of its jurisdiction under Article 226 finds that there was utter failure on the part of the registering authority to stick to the mandate of law, the court merely cancels the act of registration but does not declare the very execution of the document to be null and void. A declaration that a document is null and void is exclusively within the domain of the civil court, but it does not mean that the High Court cannot examine the question whether or not the registering authority performed his statutory duties in the manner prescribed by law. Number 59, it is well settled that if something is required by law to be done in a particular manner, it shall be done only in that manner, not otherwise. Examining whether the registering authority did something in the manner required by law or otherwise is certainly within the jurisdiction of the High Court under Article 226. Yes. So, my lord, the question is, I have to show, my lord, gross violation. Now, my lord, so far as, my lord, my
So what are the ground here?
Yes, my lord, I'll show to your lordship. Now, my lord, kindly takes the trouble to come to page 77 of my writ petition. My lord, this is the, my lord, deed my lord, which I say is a result of which registration has been done illegally by the my lord, concerned authority. Now, my lord, kindly takes the trouble to see, my lord, page 77. My lord, this is in Bengali though. My lord, lordship is my lord, I can.
Yes, what is the
My lord, the only my lord issue, two issues are coming up, my lord. So far as my lord, lordship will kindly, my lord, the thing is, my lord, it has been registered. Seller is called to be me, my client, but my lord, they are saying that their respondent 4 is the seller as a power of attorney holder, and 5 is the buyer. My lord, I say I have never authorized this person at all to sell past portion of my property. My lord, what has been done is, my lord, at page 81, lordship, that is the page where the signature and the thumbprints are there. At page 81, my lord, only the photograph of the POA holder, supposed POA holder, not even POA holder, my lord, alleged POA holder, and my lord, the buyer. These two persons' photographs or fingerprints are there. My lord, according to the Registration Act, by virtue of an amendment introduced in 2005, my lord, 32A, capital A of the Registration Act was introduced, my lord, whereby it was made mandatory that the photograph and the fingerprints of all 10 fingers of both the buyer and seller. So, my lord, not the POA holder. It is clarified.
No, if it is through the power of attorney, if it is through the power of attorney holder, then the power of attorney holder has to sign and put the finger.
Yes, my lord, I'll show to your lordship. My lord, this has been dealt with by the Honorable Supreme Court. This has been dealt with by the Kerala High Court directly, our Madras High Court, our Guwahati High Court. My lord, I'll show those judgments. My lord, I'm carrying those. My lord, so far as my lord, I need to, my lord, satisfy your lordship regarding the statute itself. My lord, how the process of registration falls is, my lord, I am, my lord, handing up the Registration Act first. Aage act ade. TP Act really. Well, the interplay between the sections, well, I'll just indicate. Yes, yes. 32 capital, well, I'm handing up the book. And my lord, one other thing I also wanted to indicate, my lord, the deed also, my lord, carries only one witness. My lord, under the TP Act, attestation definition means that it should be attested by at least 2 witnesses. And my lord, the Registration Act mandates that the registering authority has to ensure that the laws of the land are otherwise complied with. So that is also another second point. My lord, I'll just come to, my lord, the first point. Yes. Yes. My lord, kindly takes the section 32 capital A once.
Yes.
My lord, this is compulsory affixing of photograph, etc.
Yes.
Every person presenting any document at the proper registration office under section 32 shall affix his passport size photographs and fingerprints to the document. Now, my lord, provided that, this is very vital, provided that where such document relates to the transfer of ownership of immovable property, the passport size photograph and fingerprints of each buyer and seller of such property mentioned in the document shall also be affixed to the document. Now, my lord, I pause here for a moment. My lord, the section 32, my lord, deals with persons who are capable of presenting the document for registration. My lord, without going much into it, my lord, 32 subsection subclause C says that by an agent of such person, representative or assigned duly authorized by power of attorney. My lord, I am not on that. Now, my lord, I am on 32 capital A. So, my lord, even if a person is presenting who is a power of attorney holder, what is the additional requirement that has been prescribed in 32A? Now, my lord, there are, my lord, 7 elements.
No, so if you go by your submission,
yes,
32 provides the power of attorney holder, agent, power of whatever
to present.
Present, okay. So, and if this court accept your submission 32A, the seller has to be present before the authority.
My lord, that is
how the
exactly, my lord, may I, my lord, there are, my lord, kindly seize, my lord, the 7 elements of 32A. My lord, first is, my lord, every person presenting.
Correct.
Then, my lord, any document under section 32.
Correct.
Now, my lord, fourth is shall, what he has to mandatorily do, affix his passport size photographs and fingerprints. Now, my lord, so far as the proviso is concerned, that is specifically talking about, my lord, the conveyances which are, my lord, conveying the property to a third person. So, immovable property is getting conveyed.
Correct.
my lord, provided such presented document relates to transfer of ownership of immovable property, the passport size photographs and fingerprints of, now my lord, I pause here, each buyer and each seller. So my lord, passport size photograph and fingerprint of each buyer and seller of such property mentioned in the document shall also, my kindly work marks the word, my lord, also.
Where from you reading?
My lord, 32 capital A of the section, my lord, section 32 capital A itself. My lord, proviso of that. My lord, kindly take the proviso once.
Proviso of the such document relates to the transfer of ownership of immovable property, the passport size photographs and fingerprints of each buyer and seller
Yes.
of such property.
Yes, see, mentioned in the document. So my lord, the named seller and the named buyer. So my lord, if I am the seller, he is the power of attorney holder. My lord, my fingerprint, my photograph are to be annexed. My lord, each buyer and each seller, and my lord, kindly notes the word shall also. So my lord, it goes over and beyond the normal requirement of the basic section. The proviso adds, my lord, additional requirements in case of immovable property getting conveyed. My lord, kindly, my lord, takes, my lord, that context into, my lord. And now, my lord, it has been also, my lord, my lord, this, how this law came to be, my lord, I was able to, my lord, see the bill. Kindly seize the bill. Why this was done? In 2001, my lord, I stand corrected. It is a 2001 amendment, not 2005. Lord, will kindly, a second. Well, this is the Act 48 of 2001.
Yes.
Further to Act Registration Act, my lord, kindly, my lord, takes section 5 of this Act. After section 32, my lord, on the second page. Lordship has got it?
Where from?
My lord, in the second page, section 5 of the Amending Act. And section 7 I'll also place, my lord. May I, in the second page of that, my lord.
Yes, the second proviso of the registration.
263, not the second proviso, my lord, the, yes.
Yeah, that is not there.
Oh.
You have given some other.
এটা কি দিয়েছি? Oh, this is also there. My lord, this is also there. This is the, my lord, the bill. I'll also place this. I'll also place this.
Yes.
Very well. Now, my lord, section Act 32 of the Registration Act, the following section shall be inserted, namely,
section 32.
Every person presenting, my lord, this was done by this particular amendment.
Yes.
And my lord, also section 7 is vital of the amending act. In section 52 of the Registration Act, subsection 1 after clause A, after the words and place of presentation, the words, figures, and letter, the photographs and fingerprints affixed under section 32A shall be inserted. So, my lord, 32A and how it was, my lord, embodied in the section 52. Lordship will see, my lord, I'll place section 52. How, my lord, what is the things to be done by the registering authority are enumerated in section 52, my lord, and that includes, my lord, to check for this endorsement under section 32A. Now, my lord, this is also, my lord, I wanted to, my lord,
that's correct. That's what I'm telling.
Yes,
That's
yes, my
what I'm
lord.
telling. So how if a person is transferring or executing a deed through the power of attorney holder, and power of attorney might be a registered document. So how in the deed the seller's photograph, okay, photograph might be, how the fingerprint can be?
Yes, my lord. This is why, my lord, I join issue, my lord. This is what, my lord, now I'll place. This is the bill. Kindly takes, my lord, the third suggestion at the second page. The third paragraph from the top, third suggestion. Well, this was precisely done by the legislature to, my lord, introduce an additional layer of security so that, my lord, immovable property cannot be transferred in this manner, abusing the, my lord, process of registration.
I totally
Kindly
agree.
sees, my lord, third suggestion in the second page. The third suggestion was with which the bill was introduced, the fingerprint and the photograph of the person going in for registration of the document be there on the registered document itself. Kindly sees, my lord. This is third paragraph. Lordship has
No,
got
the
it.
third suggestion was with which this bill was introduced, the fingerprint and the photograph of the person going in for the registration of the document to be there on the registered document
Itself.
Correct.
The standing committee felt that the fingerprint of the photograph of both, that is the buyer and seller, must be on the document itself. The government has accepted this suggestion. So, my lord, the inception of 32 capital A is because the government wanted to introduce an additional layer of security when the question of conveying immovable property would crop up.
That's correct. But the problem is that the affixing a photograph and affixing of the 10 fingerprints is not to be done in sitting in the office, sitting in the chamber.
May not be.
It is to be taken in presence of the sub-registrar or
May not.
registrar, whoever it may be, before the registering authority. Correct. If it is before the registering authority, then how so then the power of attorney has become useless?
My lord, there is a distinction, my lord. I would, my lord, there can be two scenarios. My lord, lordship, my lord, is contemplating that if something like this has to be actually in real
Correct.
world has to be done, so my lord, they have to come and affix the fingerprints in front of them.
Correct.
No, my lord, lordship, there are, my lord, also, my lord, cases, my lord, where is, my lord, the document can be, my lord, presented for registration after 4 months of execution. If it is in the foreign place also, my lord, it can be done.
That's right.
So, my lord, it is not necessary. My lord, the question is not that whether the fingerprint is actual fingerprint of the person or not. The question is not that whether they came to the office and put the fingerprints in front of them. My lord, photographs is something else, but fingerprints is a direct biological, my lord, marker.
Yes.
My lord, so far as when the question of fingerprint comes up, my lord, the question is the registering authority cannot, my lord, do a forensic audit to see, my lord, which is the actual fingerprint. But my lord, whether the fingerprint of the seller, something on that heading is already there or not, this is the minimum check that has been prescribed by the statute. Well, I'll show to your lordship. But this is particularly prescribed, and one of the high courts have interpreted it so already. That, my lord, this particular requirement cannot be given a go by because this is a.
It cannot be go by. If it is not given a go by, then 32 provides agent.
Yes.
32C
Yes.
provides agent.
Yes.
32 proviso says that this photographs and the seller's fingerprint.
Yes.
Correct. So how it has to be?
My lord, I'll my lord, try
What
to,
is
my
the
lord,
rule on that?
I'll satisfy your lordship. My lord, I'll try to, my lord, also reconstruct the scenario. My lord, suppose my learned friend is unable to come out of his place. He, my lord, is authorizing me as a POI holder to, my lord, carry out a sale to my other learned friend.
Correct.
So, my lord, he gives me a power of attorney. And my lord, what I do as a power of attorney holder, my lord, what I have to do is I have to put his name, his photograph, and I have to bring it to him. You put your fingerprints, then I carry that document and present before, my lord, the registering authority.
Can't be.
But otherwise,
I am telling why can't be. Because the fingerprint which you are relying upon on the deed, that fingerprint is to be put in the registrar of the sub-registrar office, not only the white paper.
My lord, so far as, my lord,
so how tomorrow you will give that, and that fingerprint is not in the registrar's register. How you can match it? And what purpose should be solved?
my lord, I'll tell you, lordship. My lord, the purpose is, my lord, this is also, my lord, discussed. I'll show the judgments. But, my lord, before that, my lord, the purpose is, my lord, this is an additional layer of security.
Correct. I am totally agree with the law which has been amended as proviso 32A proviso.
Yes, yes, yes.
We cannot go by.
Yes.
Now the court can interpret that. If the court will interpret on that way, now it is necessary the photographs and the fingerprint of both seller and the purchaser. Either of the party might be appear through the or executing the deed through the power of attorney. So if it is the through the power of attorney, through the power of attorney, how now you have given suggestion? You give the suggestion. Yes, I will go to the original seller and take the photograph and take the fingerprint and bring the document annexed with the deed. So that can be, but the fingerprint has to be given in the register also.
Now, my lord, I join issue, my lord. The alternative argument, my lord, what I said, my lord, was one situation, and my lord, what has fallen from your lordship, my lord, I appreciate that. To really give it effect, the person has to come to the office. Now, my lord, lordship says that then what is the point of the power of attorney? Now, my lord, this is also there, but my lord, kindly looks at it from this way. My lord, when a statute legislates something, and especially an amendment is carried out, so my lord, the amending legislature is aware of the existing statute, and they are still inserting it. So, my lord, if something is actually found to be contrary or repugnant, then, my lord, the amending portion would supersede, my lord, the previous portion. My lord, that probably also need not be gone into. But because, my lord, when a statute is, my lord, legislated, my lord, the courts will always try to, my lord, implement all the sections thereof. So, my lord, if 32A and 32 are read together to mean that the person has to come to the registering office to carry out the fingerprint affixation. So, my lord, that would be the interpretation. My lord, 32A will not be rendered nugatory. It is better to, my lord, give both of them effect. And if that is, my lord, this is, my lord, possible interpretations. Well, this is something, my lord, which has perhaps not been dealt with too much by our High Court also till now. So, my lord, if a question arises that to give effect to something, I have to give effect to both the sections or I have to pick and choose one, my lord, I would, my lord, in my own humble understanding, my lord, I will have to try and, because that is the principle of harmonious construction, that the courts will always try to implement all of the sections of the statute unless it is completely repugnant. So, my lord, there is no repugnancy as such with 32. 32 says you can authorize someone to go and do it. 32A says that you have to put the original person's signature also. So, my lord, if both are read together also, then also, my lord, my case would survive so far as, because in that event also the question whether or not the fingerprint should be there, whether at home or at the registering office, is another question. But that question must be, my lord, answered in the positive that yes, both need to be there. So, this is my interpretation.
See, again, there are two things.
Yes.
Power of attorney, okay, sold the property, given the power of attorney, left India or left the West Bengal, whatever it is.
Yes.
So he will not in a position to come, the power of attorney will do that. So as per this, if the seller has to come and give the fingerprints, there is no possibility. Then the power of attorney would be frustrated. Correct? Power of attorney would be frustrated. If we'll say, the signature can be taken, how the signature can be taken?
Signature is not required.
No,
fingerprint,
how the fingerprint can
yes.
be taken?
Somewhere or a physical contact is required with the document.
How?
It can be, my lord, if I, my lord, have to interpret, my lord, it can be at the other place or it can be at the registering office. But the question is a physical contact with the finger.
Even the regular sale deed also, if the person is bedridden and not in a position to come to the registrar office, there is a provision for commission, and even registrar office will go to and take the signature. There is, but here what would the effect of the power of attorney?
I'll tell you, lordship. Let me, my lord, also, my lord, take you through the series of sections, 2, 3, 4 sections of the Registration Act itself. Yes. First, then, my lord, then I'll also the registration rules of Bengal. My lord, those are also important. My lord, kindly, my lord, notes my submission. My lord, I say, my lord, section 60 of the Registration Act requires section 59 to be fulfilled. I'll come to that. Section 59 requires section 52 to be fulfilled. Section 52 requires
from
section
33 to 62.
Yes.
This is a total rules,
total
procedure for the registration.
Grateful.
Correct.
Grateful. My lord, kindly, my lord, comes back to 32 capital A proviso. My lord, I'll just place one by one. My lord, so I'm skipping the first part because this is only concerning immovable property. Provided that where such documents relates to the transfer of ownership of immovable property, the passport size photograph and fingerprints of each buyer and seller of such property mentioned in the document shall also be affixed to the document. Now, my lord, kindly takes, my lord, section 52 once.
Yes.
Yes. Now, my lord, section 52, subsection 1. Duties of registering officers when document presented. 1, clause A. The day, hour, and place of presentation, the photographs and fingerprints affixed under section 32 capital A and the signature of every person presenting the document for registration shall be endorsed on every such document at the time of presenting it. Now, my lord, I pause here. Document presented, photographs and fingerprints affixed under section 32A, this was introduced by way of amendment, shall be endorsed on every such document at the time of presenting it. So, my lord, when the document is presented, the endorsement has to be there that there is a section 32 fingerprint and now, next is section 59. Kindly see. Endorsements. Lordship has got it.
Yes.
Endorsements to be dated and signed by registering officer. The registering officer shall affix the date and his signature to all endorsements made under section 52 and 58. 52 is vital. Relating to the same document and made in the presence on the same day. Endorsements are missing in our deed, by the way. That is also my point. Now, my lord, so 32A, 52, 59, then my lord 60. certificate of registration. This is one of the culmination of everything.
Registration.
Now, my lord, after this is subsection 1, after such provisions of the sections 34, 35, 58 and 59, 59 is vital, my lord, as applied to any document presented for registration has been complied with, the registration or registering officer shall endorse thereon a certificate containing the word in quotes registered together with the number and the page of the book in which the document has been copied. 2. Such certificate shall be signed, sealed and dated by registering officer and shall then be admissible for the purpose of proving that the document has been duly registered in the manner provided by this act and that the facts mentioned in the endorsements referred to in section 59 have occurred as mentioned, as therein mentioned. Now, my lord, I kindly sees, my lord, 32A, certification, endorsement, not there. My lord, section 30, section 60 is the culmination. 60 needs 59 fulfilled. 59 needs 52 fulfilled, 52 needs 32A fulfilled. So, my lord, this entire chain of statutory mechanism could not have been triggered in the present case because one of the 32A endorsements were not there in the document.
That's why, see, that's why the question is whether if the deed is executed through the power of attorney holder.
Yes.
What would be effect of the 32A?
But it will render the registration nugatory.
Proviso.
I am not on
Because
the deed.
the power of attorney says it is not possible me to appear in person, so I am giving the power of attorney to so and so execute the deed.
Now the power of attorney here is also not registered document.
That is different.
That's
thing.
a different issue.
That is different.
Yes,
thing.
yes.
No,
But yes,
32A proviso.
yes, yes.
So
yes.
that is the mute question.
My lord, that would, my lord, perhaps, my lord, will come to, my lord. I have a direct authority from Kerala High Court which says so. But so to answer your lordship,
what the Kerala says.
yes, yes, I'm handing it.
Hey,
Single bench. This is yes.
It will take time, no?
It will take some time, my lord.
One matter is fixed. Come tomorrow.
Kindly fix a date for file and report, my lord.
Not really. This is a point of law.
Mainly a question of law.
Point of
There
law.
is a digital fingerprints also, which is taken.
That is subsequently.
Yes,
That is subsequently. You take the instruction from your officer. How? Because I know, but I don't know with regard to the West Bengal. Because the persons
My lord, there is a supplementary affidavit as well. My lord, the persons who have now gotten hold of that part of my property, my lord, they have created a construction. My lord, I have a some
Okay.
But my 50 years old mandir, my lord, it is the Chinnamasta mandir. It is unable to, people are unable to access it because of this.
Learned counsel for the
But
petition.
this supplementary may be taken on, but I'll serve a copy.
Has filed the supplementary affidavit after serving the copy. Learned counsel for the state. Let the same be kept with the record. Learned counsel for the petition argued the matter at length, but due to paucity of time, matter could not be taken up for hearing. Let the matter appear tomorrow under the same heading.
And my lord, the service also may be kept on record. My lord, I have filed a supplementary affidavit. I'll give in a copy. This is grateful. My lord, lordship is keeping it tomorrow.
Tomorrow.
My lord,
Under the same heading.
yes, yes. So, my lord, can I get my book?
Yes, book there.
And copy of
book there. The book there.
My lord, the copy of the bill may be retained. with
Let
the
that.
record. Yes, yes, let it be retained. Grateful. Namda Deep.
Lord, I am appearing for the NCB as well as for Union of India.
Yes.
May I give a short reply? Lord, I have understood what is their point last occasion, although I was not present. Lord, two things I need to point out before your Lordship's court. My Lord is already aware of it, but it is my duty to, my Lord, apprise your Lordship's court. Number one, Lord, your Lordship knows this is a preventive detention. Lord, it flows from Article 21, Lord, 5 of the Constitution, where, my Lord, to prevent for illegal trafficking of drug, Lord, this preventive detention usually being imposed by the competent authority. Number two, your Lordship is already aware of it, that, Lord, so far as the bail is concerned, it has nothing to do with the preventive detention.
Nothing.
Even if the person is in custody, if the authority, Union of India thinks.
That's why the provision
Yes,
has been
if
there.
they thinks, Lord, it is for the betterment of the country to prevent the, Lord, the illegal trafficking of drugs, they can always invoke this provision. And Lord, I can show it from the, Lord, the record. Lord, each of the provision has been followed by the Union of India as well as by the competent authority. All the provision in terms of P10DPS. Section 3 has been complied with, Section 5 has been complied with, Section 9 has been complied with.
Now, the question is that you
Yes.
might be complied with.
Yes.
But the authority, the board where the matter was taken, who has confirmed the order of the detention.
My lord.
The board has, before the board, the document has to be placed.
All the documents were placed.
No. I am telling so.
Yes.
There are 3 cases only.
Not only 3 cases.
Before the board. Before the board. That's why I'm asking.
But NDPS, so far as 3 cases is concerned.
Correct.
But he is a, it is also.
Might be that
This
is
is
taken by the
P10
Union of
only.
India. Might be that may taken by the Union of India with regard to
Yes.
smuggling and all these things.
Right.
I have gold is smuggling and all these things. I have gone through that. But before the board, only 3 cases were
considered.
And in the 3 cases, the NDPS case, only 1 cases that is there's only 1 case there is a seizure. The other seizure is not there. But the board has been placed. There are on all the 3 cases there is a seizure.
No, Milord, board, Milord, subject to your lordship's correction, board has said so far as the cases are concerned, these are the recovery. And ultimately the kingpin is the present petitioner, under whose instruction illegal trafficking was carrying out. But this is the finding of the board. And Milord, your lordship will also finding from the order of the board, Milord, he is also an accused of a DRI case. He was a smuggling because this area
that is, my lord, I
my
object.
turn.
No, I
Milord,
object.
It's my turn. It's my turn. Let me complete.
This is not
Milord, it's a
relevant.
bordering area. Milord, the person, he belongs to Bonga. If your lordship knows the geographical position of that
the
area.
reference is different before the board.
No, Milord, kindly see the reference.
See.
Kindly see the reference.
And my lord, we are not dealing with NASA.
Yes.
Or
Kindly see the reference.
Safema Coffee Posa.
Give the report. Where is the report of the board? I have written that report to you. Where is the board report of the board?
Yes. Milord, I have a copy, but it is marked. Your lordship will, may I read it, Milord?
Yes.
Milord, your lordship is saying that so far as the seizure is concerned, your lordship will find the case number. Only case number, what is the seizure and quantity. It is not that it has been mentioned, it was seized from the present petitioner. What was the, Milord, the actual case? That has been, Milord, briefly, Milord, it has been stated here. And kindly see, during the course of the investigation, it was unearthed that the detainee Gautam Mondal is a pivotal of managing of organized syndicate involving large scales of trafficking of narcotic substance, particularly sensitive cough syrup. Heavy recoveries of narcotic from multiple seizures were made. It was never said from his position it was made. The transaction involved sophisticated and well-planned transport of logistics utilizes various modes of including trucks and parcels to send fabricated address. The detainee maintained close coordination with multiple co-accused of the individuals, facilitating the seamless booking, dispatch and delivery of the contraband. This conduct evidences a highly organized and methodical operation, functioning the efficiency of the precision of the finally turned mechanism. In addition to directing the smuggling operation, the detainee was handling the financial proceed. Not the proceed in terms of the act, not the entire financial, not the proceed were also seized by the authority, arising out of the illegal trade.
Seized by the authority in which case?
The NDPS case. His properties has been seized. His entire property in terms of the act, your lordship kindly see section 62, 62, 63, it can be seized and freezed. That has already been done. And he is...
That with regard to his property was seized.
Yes.
With regard to what you are telling that, with regard to selling, and he has grabbed all the things from this business.
Huge. He acquired huge property and assets and also cash, my lord, in his bank account.
Okay.
Now kindly see, my lord, the DRI is investigating the involvement of the detainee in smuggling of gold. My lord, that is the reason I told you, lordship, it's a cross-border, my lord, the offense. including my lord, this, the,
Where is the reference to the board?
my lord,
Whether this was the reference to the board.
but it was placed, it is it's board's order, my lord. I am reading the
Board's order, where the, see, board has to decide with regard to the reference.
the entire records are, my lord,
No, entire record might be, but the board has to be with regard to this case.
Yes, kindly see their writ petition. Kindly see their writ petition. It was considered by the board. Page page 142. No. Your lordship will find DRI cases 146. This was placed before the board. My lord, what it 146?
Yes, 146.
Yes, 146. My lord, the last chart. Other involvements. So it was very much placed before the board. And then the board has come to a conclusion, my lord, this is a case where, my lord, this is a clear case of, my lord, illegal trafficking of drugs.
Yes.
Kindly see, my lord, the financial investigation, this was also considered by the board.
Yes.
Following the Gautam model, that is your arrest.
No, this is not the board. This is with regard to the.
This is relied upon document. My lord, this was placed before the board. And on this, my lord, relying on this document, the order was passed.
Okay. And why it is to be taken to the Jaipur?
Yes. Now the Jaipur, your lordship, kindly see.
Why the Jaipur?
Just 1 minute. My lord, there is a screening committee meeting, and my lord, it is the decision of the authority, my lord, who has detained him, that is the NCB, on their proposal before the central government. He was transferred to Jaipur because initially the screening committee says either in Assam, Andaman Nicobar, or any other state. So why not Andaman and Nicobar? Your lordships knows, my lord, the language and the other, my lord, the behavior of the accused and all in Andaman jail and as well as the Assam jail is almost similar. So they chose, so far as Rajasthan is concerned, the language is different, the other things are different. So that is the reason they have been chosen.
If you say so, then the letter he has written in Hindi. Jaipur is a Hindi place.
He has written in Hindi, but the communication, your lordship knows.
Because they have taken the plea,
yes,
because he don't know the Hindi language. He is only knowing the Bangla language. That's why the interpretation has not been given with regard to all the decision taken by the authority. Correct. Now your learned advocate on the last occasion to contradict that, given the letter submitted by the petitioner in Hindi language. The petitioner is writing in the so much good handwriting in Hindi. So why the Jaipur?
No, that is the reason, my lord, because he was
Jaipur. It is not the only the Jaipuri.
Because, my lord, illegal trafficking, it was entire eastern region where he used to operate. From the investigation, it came out the entire eastern region where the person used to operate. So to detach him from eastern region, it is the decision of the authority.
Where is the decision?
Yes, my lord. Kindly see this. My lord, I am reading it. Kindly refer to mail number so and so under subject requisition of document. This official submitted some details. Further, it is also submitted that one of the preliminary reason for keeping the accused lodged in Rajasthan was ensured that he is remained outside the eastern region.
So why not in Delhi?
But I am telling you, lordship, most of the states initially, see, till 2025, Delhi doesn't have any board. Even West Bengal.
No, here
that is the central board. Central board is there. But
Correct.
the problem is this, my lord. The central board, the government of Delhi is directly come under the Home Department, where the order has been issued by the department. So that is the reason. Either in other cases also, when I was appearing, most of the cases they prefer to shift this kind of person in Jaipur. Because the board is there and my lord, they will be detached from the, my lord, the region where they used to operate. And my lord, it is the discretion of the, my lord, the agency, my lord, where they can decide to keep him under the custody.
Yes. That's all.
Yes.
No.
My lord, if any other queries, your lordship can ask me.
But where is the order?
Order?
You are not brought yesterday. Where is the board order?
But the officer, the
No, why you're not, madam? This is not
No,
the
it's
way.
not.
On that day, you told that my officers will come today. Now you bring the other advocate before this court today. Your officers are not there. What document you produce on that day? You are not producing the document before this court. Please,
My lord, yesterday they.
please, Mr. This type of the practice, please don't do before this court. If your one advocate is appearing, you take adjournment, my senior will appear, you take the senior advocate. Tomorrow you take the adjournment, and where is your officer? She assured before this court that the officer will come with all documents. Where is the documents? Otherwise, you will refer your matter to the bar council, nothing else. This court deprecate this type of the practice. You assured before this court, my lord, I will bring all the files because the persons who, where is the files?
Well, yesterday they said.
Please, Mr. Majumdar, don't, otherwise something more will happen.
It was my fault, my lord. I should have checked him, my lord. I asked them to come at 1, but somehow.
If you are engaging the senior advocate, you should have been informed the senior advocate what you have placed before this court. Maybe why you are not informed that you wanted to this court wanted the whole file. Where is the file?
Go and call him. Just go out and call him.
He has produced on the original book.
I understand, Lord. I understand. Lord, it is our fault. Lord, kindly don't.
My lord,
yes,
few words in reply. My lord, first of all, my lord, my learned friend has not, my lord, then addressed the issue of the link becoming stale. The man was arrested, just for recapitulation, in November. The proposal was sent in December. The decision was taken in February. The order was passed in March. They, for reasons best known to them, waited till 25th of June. This period of 1 year, in fact, will be over on Wednesday. 24th of June will be 1 year over. First. So this and the case related to the seizure was of February 24th. Man was arrested in November 24th. I have shown to your lordship the manner of the seizure, the only one case. First of all, the judgment of the Honorable Supreme Court that I have relied on, which the Honorable Supreme Court has said that there must be a link, absolutely live link. And second of all, the other decision where the Honorable Court said that already the man is in your custody. Whether this necessitated at all, because he was not on bail at that point of time, the passing of that detention order in March, 4 months after he was already in custody. These have not been addressed. My lord, the second, my lord, he has drawn your lordship's attention to the grounds which were supplied to me, 142, 6. And the chart, the DRI chart.
Yes, 1.4.
Yes. My lord, 146, 1.4. My lord, none of these cases, my lord, I am arrested. None. First of all, these are cases, my lord, which do not relate to NDPS. The board was dealing with NDPS case. If this had been so, if these cases are pending also, they could have imposed SAFEMA, COFEPOSA, other detention laws also. None was done. None. And my lord, my learned friend was drawing your lordship's attention to section 3. If your lordship sees section 3, it contemplates only narcotics. My lord, এটা mark করা, এটা marking আছে. So, my lord, subject to correction by my lord, 1.4 is superfluous so far as the consideration is concerned.
Now,
Yes.
these are the two limbs. The other limb of my argument, my lord, I had indicated to your lordship on 11th of August, I was served with the notice saying that 12th of August, I should be produced for hearing, my lord, only 1 day's time or overnight. And my lord, there is nothing, they could not come up with anything to show that I was given that opportunity to consult any advocate, to get any representation, anything, nothing of that sort. This practice has also been deprecated. My lord, I have placed the judgment that sometime reasonable opportunity must be afforded for a, my lord, what should be a reasonable here opportunity.
No, but with the 12th, the meeting was not held subsequently. No, prior to that.
11th, it was served.
Yes. That's why the document
And
is not. When the first day was, it was adjourned. What was the first day of the
Kindly see
meeting?
151 of their petition. A written representation was given by them before the board. Kindly see 151.
This subject to correction will after the hearing, not before.
This is a 28.
28.
Yes.
So after hearing is over already. Decision is taken. So my lord, the language barrier which, my lord, they
kindly see the language once.
Are Baba, আমি শেষ করি, দাঁড়া একটু, এক মিনিট. My lord, they, according to their submission, they removed me from West Bengal so that I cannot communicate in my vernacular. My lord, precisely this is my case, my lord. Precisely. You remove me to such a place. If language barrier, my lord, operates as a bar for you, it operates as a bar for me too. I could not effectively represent myself. There is nothing to show that there was any translator. And the other issue, my lord, why not Delhi? My lord, I have already drawn your lordship's attention to 209, my lord, their circular 3.
203.
209.
9.
Para rule 3.
Yes, yes.
And this is followed by 5, rule 5. I it clearly said, when there is no state advisory board constituted under the PIT NDPS Act 1988 in that respective state where the detainee has been detained, then the matter can be referred to the central advisory board. In Bengal, it is not there. The central advisory board is in Delhi. The order is passed by the central government. This is clearly, it is their circular I am relying on.
Yes. Yes.
And so far as the trafficking is concerned, 3 cases, my lord, will find in 2 cases. It is only based on co-accused statement. In the 3rd case, a seizure is made 17 days after a PC is over. Another PC is taken and done, my lord. This is the only complicity so far as NDPS. Throughout India, as they said, I am a operator, this, that, racket, no other FIR or outside West Bengal, or apart from these 3, in fact, so far as NDPS is concerned. And my lord, all the
that is the seizure.
My lord, seizure I at 1. Page check. Seizure list of page.
Yes, 99.
99. This is 8 months after the case. The seizure is 5/12/24, 8 months later, and placed in a bamboo shed open space, fish pond. Conveniently for 8 months, the goods were kept there. Open, 10 months. 10 months, it was open space, it was kept there. And this was after I had completed PC in Calcutta case, I was taken into PC in this case, and then 17 days later in PC.
First, when you have been arrested, which case you are arrested? On which date?
He was arrested NCB crime number, case number 15 of 2024. Dated, date of arrest is 13/11/2024.
13/11? And the seizure is 5/12.
And other cases treated as arrest.
Yes, other two cases, Calcutta and the Bhadreshwar, he was shown arrested in these two cases.
Treated as arrest. Yes. Yes.
And the last, my lord, it has been repeatedly, my lord, stated by the Honorable Supreme Court that where the general law relating to that particular offence, here the NDPS Act, is sufficient to deal with the man or to keep him in custody, my lord, detention orders need not be passed in such circumstances. And lastly, in all the three cases, this Honorable High Court has granted bail to this man.
Yes.
Obliged, my lord. These are all.
Number one, my lord, it is settled law by the Supreme Court. Even if a person in custody, detention order can very much be passed. If your lordships want that judgment, I have this judgment.
No, that's correct.
It is a settled,
that is
proposition.
not if it is correct,
Second,
but
the report which your lordships was supposed to see, this is the said report. Okay. And all the documents are here. Your lordship can see it. Yes, sir.
can you justify NDPS the board can be taken into consideration the other criminal activities other than the NDPS matter?
NDPS cases, no doubt about
because the board is constituted only with regard to the
NDPS cases, no doubt about it.
Correct.
But when it is a cross-border trading,
no, maybe whatever
it is a
cross-border or state to state, whatever it is, only my Mr.
Yes.
Only my submission is that a board is constituted under the specific act. And a person committed an offence under the said act. Correct. Then the detention is to be taken into consideration. So whether the board can taken into consideration of the other cases which is not coming under the purview of
at least he has 10 cases against him. The board has not considered those cases.
No, paragraph 7 is taken.
Only the DRI cases.
DRI
investigation. Where the cross-border the offences are involved.
Even that
this
the board,
number one.
Board is authorized.
And number two, your lordship, if your lordship see,
even the board is authorized on that.
7, that financial crime. Skip it. Suppose your lordship kindly skip it. Your lordship will find that board has considered the financial crime in respect of the NDPS Act.
So
yes, that is in the report itself. But my report is with your lordship I have handed over.
Which one? This?
My lord, even that, before that, the properties were frozen. Before this.
Kindly see this, my lord.
Yes.
কত পাতা যায় এটা রিপোর্টটা দিলাম যে কত পাতা ছিল রিপোর্টটা
7. In addition to the directing the smuggling operations, the detainee was handling the financial proceeds arising out of this illicit trade. So, Millard, the board has considered illicit trade of NDPS Act. 7. Millard, kindly see 7.
That's why I'm asking you.
Yes.
The DRI is investigating
this illicit trade. This illicit trade that DRI investigating detainee, this and that, and your lordship will find that
then great. The DRI is investigating involvement of the detainee smuggling of gold. How it can be? the authority, how the board can take into consideration of that.
Not only that, my lord, kindly see this. my
The
lord.
proceed crime were simultaneously laundering. 6, yes.
Yes, my lord. During the course of investigation, it was unearthed that the detainers once of managing of the organized syndicate involving large-scale trafficking of narcotic substance,
Yes.
particularly fentanyl, cough syrup, heavy recovery of narcotics of multiple seizures were made. The transaction involved sophisticatedly well-planned and transported logistic utilizes various mode linking truck parcels sent to the fabricated address. The detainee maintained the close coordination with the multiple co-accused individuals, facilitating the seamless booking, dispatch, and delivery of the contraband. This conduct evidence a highly organized and methodical operation. But this was it, functioning with the efficiency and precision of finely trained mechanism. But then, my lord, the DRI portion comes. Not only the DRI portion they have taken into consideration. My lord, kindly see. Then,
And this committee is the central committee.
and my lord, that one, my lord, kindly see the para 7 where your lordship was reading regarding DRI. The DRI, my lord, kindly skip that portion. That the DRI is investigating the involvement of a detainee of smuggling of gold, the proceed of crime of simply largest and movable properties, vehicles. The
Correct.
proceed of crime. You know,
Correct.
this is one line only. The DRI investigated the involvement of the detainee in smuggling of gold. This is one line. Then again, it is NDPS Act. The proceeds of crime were systematically laundered through investment in movable properties, vehicles, and other valuable assets. Clearly demonstrate an attempt to legitimate drug trafficking proceeds. My lord, got it, my lord. So it is a drug trafficking proceeds. The persistence involvement of the detainee in criminal activities poses a serious threat to a public health, security, and the national economy, necessitating his preventive detention. My lord, this was the order passed by it.
Okay.
Now, my lord, kindly see the next one also very important. The report is that the detainee is actively engaging in drug trafficking, which poses a significant threat to a public welfare and societal safety. The material on record established that he functioned as a key of the part of the larger, well-organized and narcotic syndicate, operating with precision and coordination, thereby increasing the scale and impact of the illicit trade. Well, it is all about this trade only. There is a reasonable apprehension that the detainee is likely to expand his unlawful business if not restrained. Considering this factor, it is necessary to prevent the detainee from continuing such activities, making this a fit case for exercise the preventive detention followed under section 3 of the NDPS Act. Lord, got it? Now, your lordship kindly see the act, that all the procedure, my lord, due procedure was followed by the authority. My lord, kindly see section 3 now.
No, this the board is the state board, the center board.
My lord,
This board is the center board or state board?
State board. State advisory.
Then you answer to the page 209.
Just 1 minute.
To answer to
209.
the 209
Of the petition.
of the petition.
And in the meantime, my lord will kindly come to page 69.
Just 1 minute. এখানে ওরা বলছে keeping the various factors conducting the hearing, government has decided all state where the detention was detained. According to the after detention of the first state of visiting, state the detention matter into refer to central authority. Oh, my lord, here, my lord, 5(1) will apply, 5(2) will not apply. My lord, kindly see. After execution of the detention order, my lord, got it? My lord, my detention order starts one, he has been shifted to Jaipur.
Correct.
Not here.
Correct.
Now, kindly see. A reference is preferably to be made to the state advisory board. So, Jaipur has a state advisory board constituted under the PIT-NDPS Act of the respective state where the detainee has been detained. Here he was detained in Jaipur, but state advisory board was in Jaipur, and that is the reason the advisory board functions in Jaipur and passed the order.
When he was taken to the Jaipur.
But he was taken to
25th of June.
25th of June. But there is also a reason. I'm telling your lordship. But this man is so powerful. But I personally appeared those matter. He was wanted in series of cases. Once this order was communicated to superintendent of that correctional home, one after the another cases, the petty offenses, but the lawyer who was conducting his case, he used to produce him in those cases so that this order cannot be executed. Then we had to rush before the High Court and taken an order. My lord, two order was passed by the High Court. My lord, kindly see these two orders so that, my lord, he can be shifted from here and he can appear from there virtually, those cases. My lord, kindly see it. And my lord knows better than us this mechanism. Once he is in jail, in petty cases, he used to be produced.
Yes.
So that he cannot be taken from the, my lord, from the jurisdiction of the Dom correctional law. We prefer two revisional application. And the court was insisting, my lord, the court was insisting his personal presence before the court, although these are petty offences. So we had to rush to the High Court, and High Court has stayed all those orders passed by the Learned
Okay.
Okay.
Now,
Yes.
one last thing. He has said, my lord, a lot about the financial things, my lord. My lord, we'll come to page 69. This is the chart sheet of the NCP plan. What was not placed at all before the board? Board was not informed. My lord, para 83. On 26th of February 2025, everything had been freezed. Now the question comes, my lord, if everything was under their control already, will this be now the ground, fresh ground for passing a detention order?
Of course it is.
It is already taken away. The man is already in custody.
No, their contention is that, so this is the financial
And
implications
my lord,
already.
my lord will see the date when it was already confirmed by the competent authority. Done and confirmed, 26/2/2025.
That itself is additional ground.
Exactly.
That itself is additional ground for his detention.
And that is the ground that why this was not informed to the board.
Okay.
My lord.
Thank you. Hearing concluded.
Deeply obliged. Lord, I am very sorry, my lord, for on the latches of the part of the officers, my lord.
No, tell
It is-
your officers
Yes, my
or
lord, they
your
should be more careful.
or your
No, I
advocates
completely agree.
or
At
the-
least they should have respect before this court.
or
my
in the office
Yes.
who are appearing before you as a junior or colleague. Tell, if you want to take time on the ground of senior, not take time on the ground of bringing the documents and all these things. The
My
court.
lord, I am really sorry, my lord. This will not, my lord, happen again.
Obliged.
Yes.
Obliged.
Deeply obliged.
the government issued a notice to compel all the government employees under a scheme to install the smart meter, which is arbitrary, a complete arbitrary.
Why arbitrary?
Because of that,
All over India, smart meter is
no,
the
but because of that, my lord, what happened?
over India, smart meter
Not
is
for
there.
all the citizens. They just we only government employee. It is not in our service condition.
Only government employee.
Yes, my lord. Kindly see the notification. I believe, my lord, after seeing this, my lord, in our state, my lord, only government employee. And not only that, they give a form, my lord, that you have to intimate to the office. The very next page is the form. Government edit.
Yes, you.
Yes, good.
Leave.
They are saving you.
No, give a leave, my lord. So, my lord, I can move it, Mr. Bhattacharya. Or no, it will not take more than 5 or 10 minutes, my lord, I believe. Any day, my lord.
Not this week.
Well, this week, because I have to, every employee ought to intimate to the office, my lord. They give a form also.
25 को रख दो 10 मिनट.
Lord, seeking
Grateful,
leave to
man.
mention one matter, but for extension, my lord, in the morning, I was stuck in the traffic, my lord, for extension, my lord.
When?
In tomorrow,
Today?
my lord. No, my lord, in tomorrow going to expire on 24th of June, my lord.
23 को कर दो.
Grateful to
To be mentioned 23 for extension of interest.
Great.
Yes, call the list. हाँ, ही कॉल कर दो.
I appear for the petitioner, my lord. This matter is ready for hearing, but my lord, the stance of the railways, this is with regard to imposition of LD in case of delay in supply of the materials. My lord, I was to supply materials, there was some delay for which the railway imposed LD on me. But there is an interim order as on this date. But my client's instruction is that there are certain materials which are pending supply from my side. The worth of the materials would be around 18 to 20 crore. My client is ready and willing to supply the entirety of the materials in 4 to 6 months, subject to what the railway says. The railways has also filed a report in the form of an affidavit saying that they will accept the delivery of the goods on imposition of LD. My client says that they are ready and willing to supply the goods, the balance goods upon deduction of LD. Whatever is left will be paid to us. But insofar as the previous goods are concerned, on which LD has been imposed and which has been challenged in the writ petition, that may be waived. That is my
That can
client's
be
instruction.
solved before arbitration, because arbitration clause is there. And another point is that as far as this case is concerned, this case not filed this Calcutta because it was happened in the Mumbai and Southeastern. This is not a Eastern Railway or Southeastern Railway. This is, I think, Central Western Railway.
They have filed
So,
an affidavit.
you know, should kindly may review as per this case is concerned, is subject to correction, Lordship. You should kindly refer before arbitration, or my lord, your lordship petitioner can made his pair before the appropriate forum. That is my instruction. That is my submission, humble submission before your lordship.
But there is an arbitration clause, but my lordship knows that even the existence of arbitration clause, there is no bar to entertaining a writ petition.
When settlement is there, arbitration may be much better.
May I
as
do
far
this?
as the impression is concerned, railway is
My
always
client has given this
consideration,
instruction based on the railway's stance that they are ready and willing to accept
because
the goods
this is
if we
not a
supply.
proper jurisdiction. My preliminary objection.
Now, what is your reply? What the affidavit in opposition says?
The affidavit in opposition.
Which paragraph you are relying upon?
I'll indicate to you. একটা রিপোর্টও ছিল না রিপোর্ট করতে হয়েছিল Yes, there is a report which your lordship will find a report dated 29 January 2026 filed by the respondents. This is, yes, the two pages.
কত date বলো?
29 January 2000. Lordship has the
This
two,
is my
2 pages report.
report. 29 January.
না ওটা তো ওনাদের কপি। But if your Lordship has that report, second page, second paragraph, first line.
Yes.
But the second page, the second paragraph, first line. The Railways is saying, in terms of the order of the Honorable High Court at dated 14 January, Western Railway is ready and willing to settle the matter with the petitioner. However, Western Railway has not agreed to waive LD amount levied upon the petitioner in accordance with the tender conditions, which is reiterated. Now, this is the tender conditions are reiterated. Now, the Western Railways, insofar as the LD is concerned, for the balance materials, my client in his instruction is they are ready and willing to bear that. So since there has been a delay, we will supply the goods, and Western Railways may impose LD, and upon deduction of LD, Western Railways may remit the sum. So far as the previous LD, which is under challenge in the writ petition, that is there is already an interim order on that. That your Lordship may decide whether the imposition of LD was correct or not. Then I can also do this, I can put my client's instruction on an affidavit or file an application, putting my stance on record, and then the railway can take instruction in that case.
No, railway has already taken instruction. Railway have a two grievance with regard to the, they will accept your materials subject to liquid LD.
Yes, that is agreeable.
And with regard to the jurisdiction of this court.
Jurisdiction, I shall satisfy your Lordship so far as the legal point is concerned. And
what is a prayer?
My prayer.
What is a prayer in the writ application?
Kindly takes page 34. In fact, page 35, that's the actual prayer.
Reasonable extension and supply the materials of balance. That is the same.
That is the same. Railways are willing to accept. I am agreeable also.
Refund the entire amount, 1 crore. What is this?
This is the LD which has been imposed for the past amount.
How the writ court can decide in
because this has been absolutely arbitrary.
Maybe.
And devoid of against the contractual clauses.
Kindly see that my instruction, previous instruction, kindly see. 7th of July, Malar, kindly. Last page, Malar. 7th of July 2025. Lagbe tomar? Kindly come to my last page, Malar. The respondent with all regards the Honorable Court submits the following prayer for kind of consideration. Number 1, jurisdiction.
I will dispose of this.
Yes.
As you are ready and you supply the materials.
Yes.
In terms of as per their
stance, I shall supply the material.
With regard to the other claim, you make appropriate representation to the authority for appointment of arbitrator.
That your Lordship may leave for the time being. For today, may I put my stance on record? We'll come back to your Lordship, and then led by Mr.
Your chance will be over because by that time they will not accept. Now they are ready to accept. And tomorrow, if you file the affidavit, then hearing, then the matter, because they are taking the point of maintenance, the matter is to be heard on merit.
Yes, my lord, maintainability, my lord, we are even ready, even today to address your lordship.
Maintainability. Now the affidavit file, no?
Yes, affidavits have been exchanged.
Then, so
So-
today is ready for hearing. So why you're not
Lordship
ready
may,
for hearing?
well, in that case, Lordship may keep it in the first week of July because my lord, Mr. Banerjee is
Then
not in good
August.
health.
Second week of August.
In the meantime, I'm
The interim order may be vacant.
Yes, the interim order. Let
Yes,
me
Malad,
vacate
because
it and
this is infructuous now, Malad. Railway has already complied this,
But maybe do
as
this.
far as PR
Maybe-
is concerned.
Malad, I understand the railways, Malad,
Today
predicament.
is the fix. If you're not
Yes.
ready, then I am
Malad,
vacate
we
the
are ready,
interim
Malad.
order.
We can address your lordship on this. Malad, it is just for the resolution of the matter. We were thinking that if we could
The
supply the
resolution, that's why they're telling, okay, they will give and you are ready. With regard to the on merit, they are taking the plea of the arbitration and the jurisdiction. That is to be
Yes,
taken care of. You want to satisfy this court,
Malad,
then
that-
hearing is required.
Malad, that we can do even today. Malad, may I start, Malad, on the question of whether the writ petition will be entertainable despite existence of arbitration
And the
clause?
totally you have to argue. If the court finds that yes, maintainable, then the court has to dispose of the writ application.
Yes, Malad, very well. Malad, আছে judgment গুলো আছে তো আমাদের? প্রথম দিন নিয়ে যাওয়া হয়েছে, judgment গুলো আছে তো? আজকে fixed আছে না? হ্যাঁ? নেই? আছে, ঠিক আছে। Malad, Malad, I shall, Lordship, give me a few seconds, Malad. I'll see whether the judgments are here. But otherwise, Malad, I'll.
Even though there will be no time, 3 o'clock.
Malad, Lordship may keep it tomorrow, Malad, in that case.
August.
Malad, August, Malad, in that case, Malad, I know Malad, Lordship is going to
No,
vacate the interim order, Malad.
No option, nothing.
Lordship may keep it to, Malad, tomorrow, Malad, we'll bring the judgment.
See, you persons are taking now. I will fix that today is the specially fixed.
Yes, it is.
Then you are not ready for hearing.
But
Railway has already complied PRA, Malad.
Specifically
This matter
excluded
may
for
be
hearing.
inquest to us.
But the London Council for the petition is not ready for the same.
Malad, may I start?
Council for the petition has relied upon the report dated 29th of January 2026, submitted by the Railway Authority, wherein the Railway Authority have informed that the Western Railway is ready and willing to settle the matter with the petitioner. However, the Western Railway has not agreed to waive the liquidated damage amount levied upon the petition in accordance with the tender condition, which is reiterated. In the said report, the railway also taken the point of maintainability of the said writ application with regard to jurisdiction of this court. In view of the above, this court find that the writ petition is required hearing. This is the matter.
But I can start, Malad, today.
1st of August 2026 at 2 p.m.
But I can start today, Malad. I will be needing the.
Yes.
But I'll not take much time because this is only on a point of law.
Yes, no. Come.
But the interim order is required. Malad. That is why, Malad, I don't want to, Malad, risk it.
That's
Malad,
why
may I
you
start?
wanted to enjoy the interim order, you know,
No, Malad,
also taking the time. What can be done?
I understand, Malad. If I may start today.
Not
Malad, if I may start, actually,
you will start and my original side is there. You could have been start earlier. You have wasted a 10-minute time.
Malad,
Yes.
I was only, Malad, thinking, Malad, if the Lordship can not be, Malad, this.
I am not passing any order with regard to neither vacating nor imposing.
But otherwise, Malad, the interim order will go. Malad, we would require. Malad, we would require it. Malad.
I am saying for the after the vacation, none of the petition are coming ready of the 2 p.m. matters. One or the other matter, they are taking the time.
Malad, Malad, we genuinely thought that
So
this
this
could
court
be
is
resolved.
getting any disposal now.
Malad, we genuinely thought that it could be resolved. Malad, that is why, Malad, we thought, Malad, we could place.
Resolved. January, the letter was given now today of the June. You are not settled. You could have been given the letter. Yes, I am ready to supply. Where is that?
Malad, we have given, Malad.
Where is that? You have not filed a supplementary affidavit stating that you will supply them. There is nothing. Only you are mentioning the matter, and now you are taking the time for filing supplementary affidavit from your client.
Malad, we have, Malad, given, Malad, letters on, Malad, 6th February 2026, Malad, to the respondents, indicating that, Malad, we are ready and willing to supply the balance materials.
Yes.
If your lordship could, Malad, pass a limited, extend the interim order.
You know, my diary of this court. You persons wanted to get the matter delayed. Let the delayed without the interim order.
But if your lordship
Taking
would
into
kindly want to
consideration all the things from the balance of convenience of both the parties, the court is fixing the specific date. But you persons are not getting ready. What the court will do?
it is true. My
Yes,
lordship
yes.
is right. My lord,
Who is the petitioner?
but may I make one final, my lord, prayer before your lordship, my lord, for a limited period? Kindly, my lord, gives me one last opportunity.
Left.
They have got the opportunity. They have left.
Yes, they have left. How the court can pass an order? The court cannot change the order.
My lord, if I may.
Yes, yes.
Well, if I
What is
can
the
bring
matter?
my learned friend on the other side, will your lordship will kindly, my lord, entertain my prayer, my lord, for
What
for the
January-
last
since-
time.
Since January, you're not neither you supply the material, nor you filed the supplementary affidavit giving an undertaking. Now you're taking the time.
But
Yes,
I have
madam, what is the matter?
I have my client's instruction that we would supply.
Yes. Yes, what is the matter?
But may I make one submission, my lord, if I can bring my learned friend, my lord, either today or tomorrow, lordship may.
Then
Oh,
you have to
on the
file an
for a mentioning, if your lordship could, my lord, consider, my lord.
mentioning, I will not waste the time. Yes, madam, what is the matter?
My application, my lord, I am aggrieved by the actions of the state authorities in seeking deposit of my sporting rifle in violation of Election Commission of India norms. May I, my lord, first place, I am, my lord, by profession an advocate of this honorable court, and my lord, I am a shooting sports person who is a registered member of the National Rifle Association of India. May I place first, my lord, my identity card issued by the relevant association. My lord kindly takes page 21 of my application.
Yes.
My lord kindly sees this is issued by the National Rifle Association of India, athlete's ID card in my name.
Yes.
Now, my lord, additionally, I am also a member of the Serampore Rifle Club. I have disclosed the relevant particulars of my membership at page 22.
Yes.
My lord kindly sees I am also holding the sporting arms license since 1992 uninterruptedly and without any adverse remark ever on my record. I am a renowned shot, my lord. That is a particular category of sports person. Kindly, my lord, takes page 38 of my application, P2. This is, my lord, my arms license. Kindly sees, my lord, in the center of the document, license for acquisition, possession and carrying of arms or ammunition. At page 38, my lord has found it.
Yes.
My lord kindly sees, as per DM's order dated 3/11/92, that is the date of issue of my license. Lordship, the page discloses that it has subsequently been renewed from time to time. Now, Lordship kindly sees.
No.
My lord.
As per the DM order 3/11/1992,
yes,
the production time has been extended. But
Yes.
when the original license was
My lord,
issued?
original license was issued. Kindly sees, Lordship, licensing authority designation. This is, Lordship, the entire record. Lordship kindly gives me one moment.
My lord, I have a report.
Possibly, Lordship, top of the page, 28 April 1992. Kindly sees, Lordship, District Magistrate Hooghly. License has issued license such and such. Lordship finds it.
Yes.
In any event, Lordship, this is an admitted position. There is no dispute to this. Now, my lord kindly sees every election, the Election Commission of India issues a notification specifically exempting sports persons, particularly those who are, my lord, members of the National Rifle Association. May I first show, my lord, the parent notification dated 1st of September 2009. My lord kindly takes page 62 of my application.
Yes.
May I place, my lord, the notification instruction number 16 dated 1st September 2009. It is issued, my lord kindly sees, to chief secretaries of all states and union territories and chief electoral officers. Kindly sees, my lord, the relevant portion, if I may place directly. Page 63, my lord sees ban on carrying of licensed arms.
Yes.
My lord, this is the general ban. Now, my lord kindly takes page 64, specifically instruction 3.13. May I place, my lord? These sportsmen who are members of National Rifle Association at different levels and have to participate in various sporting events in which they use rifles will be exempted from these restrictions. My Lord kindly recalls I have already placed before my Lord my National Rifle Association membership. Kindly see His Lordship, this however shall not prevent. Also, my Lord, may I place page 74, which is a continuation of this notification. Kindly see His Lordship, it is an Election Commission of India, page 74 of my application. Dated Lordship, 21st March 2014. Kindly see my Lord, I am directed to state that the Commission has received a representation from the National Rifle Association of India, dated such and such, regarding exemption. In this connection, I am directed to invite your attention to the Commission's standing instruction such and such of 1999, which allows members of the National Rifle Association at different levels to be exempted, and other subsequent orders regarding deposit of arms and ammunition. Lordship, may I place emphasis and to reiterate that such standing instructions of the Commission are applicable in every general election to Lok Sabha or state election legislative or state legislative assembly. Now, Lordship, kindly sees. Also, my Lord, may I place page 60. Kindly see His Lordship, this is the Election Commission of India, 26th April 2022. Now, by this notification, my Lord, the ECI directed the relevant chief electoral officers to set up a screening committee at district level. May I place, my Lord? I am directed to state that the ECI, in pursuance of directions issued such and such, has issued instruction number such and such dated 1st September 2009. This is, Lordship, the instruction that I previously placed. Kindly sees wherein inter alia it has been directed to constitute a screening committee in every district consisting of district magistrate, SP, in the commissionerate area consisting of commissioner of police, joint addition. Screening committee shall commence the work of screening. Kindly see His Lordship thereafter. Now it has been brought to the notice of the Commission that the procedure laid by it for deposit of arms is not being followed strictly. In some cases, arms licensed holders are made to deposit their arms without any scrutiny of the arms done by the screening committee. Thereafter, Lordship kindly sees the direction of the Commission to ensure that the procedure contained in 3.10 and 3.11 of, my Lord, the notification that I had placed for September be followed letter and spirit.
Where is the 3.10? That is not.
Lordship, kindly takes, Lordship, the parent notification kindly comes to page 62, my Lord. Kindly gives me one moment, my Lord, I shall place.
You not disclose that.
Lordship, kindly, Lordship, Lordship, it will be annexed elsewhere also. Kindly gives me one moment. Hang on. Lordship, possibly that page is missing. In any event, my Lord kindly sees, possibly that page was missing at the time of print. In any event, my Lord kindly sees there was, pursuant to this, an order sheet that was taken out by the relevant commissionerate. May I hand over, Lordship? 18th March 2026, I have handed over a copy to my learned friend also. May I place this, my Lord? Kindly keeps page 60 open. It is in pursuance of this that this order sheet has been published. Kindly takes the date, my Lord, 18th March 2026, and kindly sees, Lordship, general election, all the recitals set out which Election Commission notifications have been referred to. Kindly sees, my Lord, page 2 of the order. Thus, may I place, Lordship, the 5th paragraph on page 2.
Yes.
May I place, Lordship? May I first place the first paragraph. I do hereby declare that issuance of license for arms should be prohibited. Ban will continue to be operative. Kindly sees, Lordship, the sportsmen who are members of National Rifle Association at different levels and have to participate in various sports events in which they use their rifles will be exempted from these restrictions. Now, Lordship kindly takes the last page of that order. The screening committee was also notified and set up. A screening committee is hereby formed for reviewing each individual case of arms license. Now, my lord, in pursuance of this order, I had made a detailed representation to the relevant commissionerate, which lordship is dated 19th March 2026, the day after this notification. My lord kindly takes page 40 of my application. Kindly sees, my lord.
Yes.
Page 40, 19th March. This is, my lord, the representation of the writ petitioner. Kindly sees, I am disclosing, my lord, at the third paragraph of my representation, renowned shot as per National Rifle Association of India, certificate number such and such. I am also a life member of the Serampore Rifle Club and the National Rifle Association of India. Kindly turns the page, my lord, page 41. In light of the general notice for weapon deposit or for the ensuing West Bengal general elections has been served upon me on 18th instant, which is this notification, my lord, I most respectfully submit this request for exemption. Now, my lord, this is duly received along with all documents in support of my exemption application, including, my lord, an affidavit which I affirm to the satisfaction of the authorities, which is at page 51 of my application, my lord. Now, my lord, no reply is made by any of the authorities to this representation. Instead, my lord, what my client receives is a phone call from the local police station saying nothing doing, you have to deposit it. I ask, my lord, for an order, nothing is communicated to me. Kindly sees, lordship, eventually page 75. I have no option but to deposit my arms with the local registered arms dealer. This is, my lord, my receipt. And, my lord, thereafter kindly turns the page to 76, my lord, where I have disclosed a printout of my WhatsApp to the concerned police officer who had made the phone call to me. Even thereafter, lordship, after I have submitted proof that I have submitted my arms, no order, no call from the screening committee, no hearing, nothing. Now, my lord kindly takes my final representation at page 77. This is, my lord, dated March 30, 2026. Kindly sees, my lord, it is issued to the Chandanagar Police Commissionerate, where I have set out the relevant facts, lordship. Kindly takes, in particular, page 78. May I place, my lord, the third paragraph therefrom. May I place, lordship? However, to the surprise and disappointment of my client, on March 24, 2026 in the afternoon, he received a telephonic communication from Serampore police station informing him that his prayer for exemption had been rejected and he must immediately deposit. Significantly, rejection of the exemption request was communicated only through a telephonic message from Serampore police station, no written order furnished, etc. In order to avoid any allegation of non-compliance, my client under protest deposited the firearm. Now, lordship kindly sees what I demand from the authorities, that is at page 79, my lord. Specifically, you are requested that a copy of the order rejecting the exemption be furnished to my client, representation be reconsidered. To this representation also, my lord, no response. My firearms continued to be deposited, lordship, and thereafter the arms dealer has contacted saying, you please take back because the election period is over. We cannot retain it any further. Now, lordship kindly takes my prayers.
Yes.
Lordship, I had filed the instant application in April. Soon after, no reply was received. My lord, I have prayed for copies of the orders, if any, at all have been passed. As to why my application, lordship kindly sees, no order has been passed. I am requesting for a copy of the order.
You got the report?
No, lordship. Kindly allows me a moment to peruse.
Your petition had no, your petition has filed the review application, that is also dismissed.
Lordship,
I think you have no instruction from your client properly.
May I see
the
this?
paragraph 5 and 6.
May I see this, my lord? Comply with communicated, had been rejected. inadvertently rejected, Lordship.
Maybe, but you are very.
Lordship, no review. Nothing has been communicated to me. Kindly see.
Your petitioner filed the review. Kindly see the page number 6. Moreover, a review petition in respect of the rejection was filed by the learned advocate of the
On
petitioner.
30th March, Lordship, that is my representation, which I have disclosed.
Yes.
Now, my Lord, no response has come to me. I possibly cannot know the fate. Kindly seize, my Lord, paragraph 6.
So what is your prayer now?
Lordship, the order be furnished. What is the basis of the rejection?
I
The
am
report.
asking one thing. What is your prayer?
Lordship, let them supply me with a copy of the order. Why I was rejected? This report with the utmost respect, my Lord. Nothing is disclosed as to why. And kindly seize, Lordship, a screening committee was set up. Where does this report with utmost respect say that it's been reviewed by the screening committee? No hearing. Lordship then calls for a report as to what is the status of the screening committee.
The report.
Yes,
What report? Election is over.
my lord. Yes.
Election is over. Where you will, your police authority will sell the rifle.
No, my lord.
Then, what is the law?
My lord, after
What is the
election-
law?
After election, it could be.
Where is the decision taken by the for keeping them unlimited time?
My lord, there is a.
And why, if you are rejected, why you are not supplying the copy of the rejection?
Yes, my lord.
Call the commissioner before this court tomorrow.
My lord.
This is the way the state is working.
I shall communicate.
Who is giving the instruction? Where is the official?
My lord.
Who is giving your instruction to you? Ask what is the situation today? Election is over.
My lord, she said she had to talk with the higher authority also.
So why the report has filed? Who has filed this report? Inspector in charge.
Yes, my lord, I see.
So you tell me you satisfy this court. Okay, the court appreciate that as per your circular it has been deposited. No problem. That is for 1 month. Election is over on 29th itself. 29th April.
Yes, my lord.
Declaration on 5th of May. So why you are not returning? Or why you are not passing any order?
My lord, as per the report, the screening committee has inadvertently rejected.
That's why inadvertently. Who is the screening committee? Then I have to see that in screening committee.
Well, the screening committee.
The names, my lord, of
Names
the
are-
members is in the 18th March order
Yes,
passed
my
by
lord.
the
18th March.
Who are the members of the screening committee? Which
My
page?
lord, 18th March, I have handed
What is the
over
page?
this order. Lordship kindly takes the last page of that order. The members of the screening committee are mentioned.
Commissioner of Police, Deputy Commissioner of Police, Assistant Commissioner of Police. So where is the when you are going to attend the new training?
Lordship, this is ongoing every time. I shall take instructions as to when the next event is and come back before my lord. Lordship, my grievance today is I am exempted by ECI circular. If
But
my
not
lord,
subsequently it is reviewed, madam.
Lordship,
Kindly come to the ECI circular which you are relied upon.
yes,
Kindly come. Page,
Yes, my
page 74.
74, yes,
Correct.
Lordship.
That is a 2014.
Yes, Lordship.
Correct.
Yes,
Now
Lordship.
thereafter,
I have placed finally, Lordship, of 2022, page 60,
yes,
where
page-
it says that it will apply to all elections.
correct. Page 60.
Yes, my lord.
Correct.
Yes,
Page
my
60. Now it has been brought to the notice. The Commissioner of Police, let down sir, Commissioner receive the matter has been directed.
Yes.
It shall be. That's why I wanted to 3.10 and 3.11.
Lordship.
What is the 3.11?
Lordship, possibly that page is missing in the circular. Kindly allows me, I shall take a printout of the entire circular and place it before my
In
lord.
some cases, the arm license holder made the deposit.
Kindly seize, my lord. This is the specific issue that the instruction aims to address. And Lordship, the screening committee is being set up. Kindly seize from this report. The report itself admits that my rejection was inadvertent. I am aggrieved by the fact that I had to deposit in the first place. No ground on which it was rejected. Kindly seize, my lord. inadvertently rejected. And 30th March is my representation, which I have disclosed. Kindly sees, my lord. Kindly takes the report submitted by the state today, my lord. Kindly takes paragraph 6 of the report, my lord, if I may place.
The petitioner has filed the present application. Directing the respondent numbers 2 and 3 to disclose and furnish the order rejecting the prayer of the petitioner for exemption of depositing. What is having rifle? What is having?
Yes, my lord, sporting rifle.
Depositing the arms and ammunition. Arms and ammunition. Then counsel for the petitioner submit that the petitioner is a member of Seram Rifle Club, and since 1992 he is Rifle Club. In the year 1992, the competent authority had issued the license to the petitioner. Full stop. The petitioner on how you are deposited, by which order, by which direction you are deposited.
Lordship, the phone call came to me from the local PS. Kindly
Receipt
sees.
of the phone call.
Yes.
Phone call from the local PS. That is the IC Inspector in charge Srirampur PS.
Lordship.
PS, comma, the petitioner has deposited his arms and ammunition due to the legislative assembly election was to be conducted on 29th of March 2026. Full stop. Learned counsel for the petition has relied upon the circular dated 21st of March 2014 issued by the Election Commission of India, wherein it is mentioned that the members of the National Rifle Association at different levels to be exempted from the restrictions imposed under the Commissioner's Office order dated 13th March 1996 and other subsequent orders regarding deposit of arms and ammunitions, and to reiterate that such standing instruction of the Commissioner are applicable in every general election to Lok Sabha / state assembly election. Full stop. Subsequent thereafter, on 26th of April 2022, the Election Commission of India has issued a circular wherein the Election Commission of India has directed all the chief electoral officers of all the states of the Union territories to ensure in future that the procedure contained in para 3.10 and 3.11 under the deposition of the licensed arms laid by the commission, why this instruction dated 1st of September 2009 be followed. Full stop. The petitioner has deposited the arms on
24th March
on 24th of March 2026, and immediately the petitioner has made an application and made a representation to the respondent authorities on where is the representation?
30th March, Lordship, my representation is at page 77.
On 30th March 2026. Requesting the authority for consideration of the request of the petitioner for exempting the petitioner for depositing his arms and ammunition at the police station in terms of the circular issued by the Election Commission of India. In terms of the circular dated March 2024. Full stop. The Learned Counsel full stop. Learned Counsel for the petitioner further submit that no order has been passed and no order has been passed even after receipt of the representation submitted by the petitioner. Learned Counsel appearing for the state has submitted the report wherein wherein it is mentioned that the review petition in respect of the rejection was filed by the learned petitioner before the Commissioner of Police Chandan Nagar Police Commissionerate on 30th March 2026, but the screening committee has inadvertently rejected the review petition of the writ petitioner on 23rd of Police Commissioner 30th March 2026. Heard the screening. Madam, you see your report, paragraph 6.
Yes, my lord.
Moreover, read.
Moreover, a review petition in respect of the rejection was filed by the learned advocate on 30th.
What they have rejected, my lord, is my first representation, 19th March.
When it was rejected?
My lord, as per the report, 30th March 2026, they have filed a review petition.
Representation. Then you read.
But
Rejected on
23rd of March.
23rd March. Yes, my lord.
So possibly what they've rejected is my first representation, my lord, 19th March. They've not considered 30th March at all.
But this, but the screening committee has inadvertently rejected the review petition of the petitioner on 19th of March 2026. Learned Counsel for the petitioner submit that the authorities have rejected the request of the petitioner on 23rd of March on 23rd of March 2026 to the application filed by the petitioner on 19th of March 2026, but the same has also not been communicated. So, considering the submission made by the counsel for the parties, this could find that the petitioner is the member of Srirampur Rifle Club, and since 1992, the petitioner is holding the license of the arms and ammunition. Full stop. As per the circular dated 21st of March 2014, issued by the Election Commission of India, it is categorically mentioned that the members of the National Rifle Association at the different level to be exempted from the restrictions imposed under the Commissioner's order dated 13th of March 1996. But in spite of the said circular, the police authority of the Srirampur police station directed the petitioner to deposit his arms due to the assembly election of 2026. The respondent authorities in their report have categorically admitted that the request of the petitioner for exemption of depositing the arms as inadvertently rejected, and as such, the respondent authorities are directed to exempt the petitioner for depositing in arms in terms of the circular dated 21st of March 2014 and to 2014 in view of the above written.
Lordship, may I pray for one small correction? Lordship has mentioned that the petitioner is a member of Srirampur Rifle Club, which is correct. But Lordship, since the exemption is categorized to National Rifle Association, Lordship kindly mentions that. I have disclosed the ID card, Lordship, page 21.
Rifle Club बोले हैं ना, as well as the National Rifle Association of India.
my lord.
ठीक है?
Dispose of the- Lordship is pleased to dispose of the matter. I am obliged.
Next. अरे कॉल करो यार मैटर. वहाँ कॉल क्यों नहीं होता? कॉल क्यों नहीं करते हो? कौन किया? Yes.
My lord, I have come from legal side, legal committee. My advocate Gauranga Chandra Das, Gauranga Kumar Das, is appointed to the West Bengal government advocate. So he is unable to fight my case. So I kindly give me a date, another date. I have already applied to the legal committee for another advocate. So
The petition is appearing in person and press for time according cases John, let the matter appear on 23rd July. 23rd July, come on 23rd July. Next.
On the last occasion, Lordship wanted us to microbiological test that only short issue now. It has been crystallized.
बुलाते. कौन बचाए आप लोग से?
Now, my lord, basically, the original copy গুলো করে দিন। দাগ মারা দিচ্ছেন কেন? সাহেবের কপিটা দিন না। কম মারিয়েছেন কিসের জন্য? On the other day, my lord,
Not today. Original side.
এগুলো বারণ করবে করতে ওকে, দাগ মারতে বারণ করবে তো দাগ মারবেন কেন?
Before the changeover, my lord. Before the changeover, my lord,
No mentioning in appellate side. Sorry. Yes.
In the morning, I tried to mention, but my lord had called.
Don't take chance before this court. This court is giving chance only one in the morning hours.
No, I took the chance.
Side, may I permit, my audience side may be permitted to mention, my lord, item number 158 of the list, my lord, I'm paying for upgradation because, my lord, the case is the petitioner's passport has been renewed.
As per the prayer made by the counsel for the petition, let the matter appear at the top on 2nd of August 2026.
Kindly see once.
Yes.
Madam, I've only paid
As per the prayer made by the counsel for the petition, let the matter appear at the top on on 3rd of August 2026. Yes.
I've only paid for consideration of my reply.
Call the list.
Permitted to mention.
Give the list.
Please, my lords, this is my, this occurs upon my mentioning, my lords. My interim order is expiring today. The interim order was issued because the matter is pending.
Who is for the other side?
My lord, the state.
Still pending before the.
Still pending, my lord. It was supposed to be listed.
The matter is listed as to be mentioned as per the prayer made by the counsel for the petitioner for extension of interim order.
Lordship,
Counsel for the petition submit that the interim the matter is pending before the
Lordship, in this matter
of this court. Accordingly, interim order is extended till the disposal of the appeal filed by the pending before the.
I am obliged.
Lordship, in this matter, I am appearing
pending before the honorable division bench. Liberty to mention.
I am obliged.
Lordship, in this matter, I am appearing for the state. Lordship, if a read petition may be served upon us, Lordship. Lordship, my appearance may be recorded, Lordship. Grateful, Lordship.
May it please you, Lordship, this is my writ petition.
Yes.
Well, challenging threatened debarment for 5 years in any government undertaking, but without any notice whatsoever.
Yes.
But if your Lordship, kindly, but could I just give in 1 minute, in nutshell, the facts? The petitioner before your Lordship
was given a,
What was the other side?
but we have served, my lord, by email
Email as well as
hard copy, my lord.
for a tracking to
But
deliver.
we have got a tracking report about 15-20 minutes back, which says it's delivered to one of the, but email we have served to all. If your lordship kindly sees, my lord.
Yes.
But could I just, but there are three respondents. One of the respondent number one is, my lord, Himachal Pradesh State Electricity Board, who had given a contract, my lord, if your lordship kindly sees the cost title once, but who had given the contract to Rail Vikas Nigam Limited, who is the respondent number 3. 2. Now respondent number 2 gives subcontracts to the respondent number 3, which is Holistic. Holistic gives the contract to the petitioner. I supply to Holistic, supply complete. I have been informed that, my lord, installation is almost complete. Payments also substantially more than 90% I have received. Supplies effected last year, my lord, within October, supplies done. Suddenly in June, just 9th of June, we were told that some test was carried out by them unilaterally where my products, amongst others, have supposedly failed. But I go there, I say that that is not possible because I give my reasons. Nothing is forthcoming from them. Then kindly sees, my lord, the notice which they give me on 12th, my lord. On 12th. On, my lord, 12th. Page, my lord, 116. Page 116 is the letter, is an email
attachment 117,
which is given to the petitioner by the respondent number 3. Enclosing therein 3 attachments. My lord will find there is mention of 3 attachments at page 116.
Yes.
Kindly turns to, my lord, page 117. This is the first letter. Kindly see, marks the date, my lord, 9th of June again. My lord, it is regarding rejection given by respondent number 1 to the respondent number 2. Here, my lord, at page 118, serial number 6 is the name of the petitioner. My lord, at page 119, the second paragraph is the proposed blacklisting, debarment. May I place it, my lord? Second paragraph. Further, in terms of the provisions contained on the contract agreement
Where
and
from you are
applicable.
reading?
I'm sorry, my lord, page 119. I'm sorry. I'm sorry. 119.
119.
Yes, 119.
Yes.
For the second paragraph, it starts with further in terms of the provisions. Of the provisions contained in the contract agreement and applicable conditions of the award, the willful defaulting manufacturers as tabulated above, whose supplied materials has failed in NABL laboratory testing, shall be liable to be debarred from participation, supply, registration, and business dealings in HPSCVL as well as all power utilities in the country for a period of 5 years, and necessary action in this regard shall be taken as per the contractual provisions. This is one letter, one attachment. 120 is the second attachment, which is respondent number 2 to respondent number 3.
1 to 2, but 2 to 3.
First one is 1 to 2. Now this is respondent number 2 to 3. Again, my lord, your lordship would kindly have a look at page 121, last paragraph. Same paragraph copied and pasted.
Yes.
The third letter is 123. This is respondent number 3 to the petitioner. This is dated 12th of June.
124, para 7. Para 5.
Yes.
My lord, paragraph 5 at page 124 and paragraph 7. So the entire thing is reportedly failed in some test. So debarment for 5 years everywhere. Now, my lord, we say that we do not have any. We write to them. That is at, my lord, page 125. That please give me the report. We just.
No, where is the page 124? Where is it?
But 124 top, my lord, para 5. RVNL has also stated that in terms of the provisions of the contract agreement and the applicable conditions of the award, the manufacturer who supplied materials has reportedly failed in NABL laboratory testing may be liable for debarment. So almost identical language your lordship has seen from the two previous letters, my lord. Then, my lord, I do not know what test, what NABL laboratory, I do not know. So I write at page 125 that kindly provide the test reports. Your lordship would find at the last line.
Yes.
I write to respond number 3, I write. Then they give the test report, which my lord will find, my lord, at page 126 is the email. That top, my lord, the report is 128.
Yes.
And just before taking your lordship to this page, there was a pre-dispatch inspection from the Himachal Pradesh, the main recipient of the goods. Their personnel were present, and I have annexed those. All my goods were tested. Okay.
Page 28 and 50.
I shall take your lordship to that, but now kindly see 128. This is the test report. Now, my lord, your lordship would find at my lord page 130 the ultimate findings. Kindly takes a look at serial number 2 first. I'll take your lordship to serial number 1. Kindly takes a look at serial number 2. My lord, we have passed, my lord, because the unit, the requirement as per IS 2713, your lordship will find in the 4th column. This was done as per IS 2713. Page 130.
130, yes.
Yes, your lordship will find there's a table.
Chemical test and
yes, your lordship would find that there in the 4th column, the heading of the column is specified requirement. As per IS 2713. Has your lordship got it, Mala? 2713 of 1980. So as per this IS standard,
which you are reading with part B or chemical?
No, my lord, part B at the top. Part B at the top, my lord.
Yes.
So your lordship would find that the testing has been done as per IS 2713 1980 standard.
Correct.
Now your lordship kindly skips 1 for the moment, my lord. I'll take your lordship back to 1. Kindly sees 2. Yield stress. So the specified requirement is minimum of 240. Our goods is 291. Then, my lord, elongation minimum is 17. Ours is 33.14. Then kindly sees the chemical properties. Your lordship will find this is in a different IS 228, my lord. Requirement is maximum 0.060. Ours is within that 0.019. And, my lord, phosphorus 0.060. It's 0.031. So we are within. Kindly sees the remarks at the bottom. Sample confirms with respect to above test except for tensile strength. So serial number 1, which I had not placed, and I shall explain why, is where we have allegedly failed. All other we have qualified. Now, my lord, this tensile strength was in IS 2713 at one point of time, but this has been deleted. Kindly comes to, my lord, page 151. IS, it starts from, my lord, page 150. No, 142. It starts from, my lord, 143.
Yes.
And your lordship would find at, my lord, page 150, this tensile strength is given.
150.
151. 10.1 on the right hand side, my lord, 10.1.
10.1, yes.
Tensile strength. But this has been deleted from IS 2713 amendment.
Tensile test and chemical analysis.
Yes, this has been deleted. Now, my lord, why I say so? Kindly see.
Where from you get that it deleted?
Yes, page 142. This is the amendment number 1 dated September 1986. Long back, deleted.
143.
143. 142. 142, I'm sorry. Kindly sees at the top, it's IS 2713.
Yes.
Kindly sees, towards the middle of the page, there is a, within bracket it says page 5, clause 10.1. 8.4 after 8.4, where your lordship would find delete, then quotation A, tensile test. So this is deleted. So my goods conform to all other requirements barring this particular tensile strength, which is deleted from the scope of the IES which they carry out the test on. Now, my lord will kindly also permit me to place the joint inspection report, which is prior to, my lord, the delivery, page 28, prior to dispatch. Kindly see who issues this, the main recipient of the goods, the final consumer, Himachal Pradesh State Electricity Board. They issue this to, my lord, this inspection report, and gives me the that report is page 29. This is the letter under cover of which it was issued. Kindly see the observation at page 29, the next page. And they check everything. Last line, offer material quality is found satisfactory, hence accept.
No, the observation visually checked.
Yes.
Yes, last line. Not the
Correct. Well, I am not for one saying that they were not authorized to carry out. That is not my submission. But I am saying that there was a pre-dispatch test which found my materials to be okay, and they issued the delivery dispatch clearance, which is page 50. They issue the dispatch clearance. Visual. And page 50 is the dispatch clearance they give after the inspection.
Not only visually, test conducted.
I'm sorry,
Not only visual.
I'm sorry, Mr. Masu wants me to once again take your lordship to page 29 once. It is perhaps, my lord, subject to correction, not only visual, because it says lot of other tests also.
No,
Subject to correction, page 29.
Yes.
Drop test, deflection test, permanent set test conducted. So all these are also there, my lord.
Where?
My lord, after observation, my lord, fifth line.
Visual check of all poles.
That is one. After that, my lord,
Lens size,
lens size. Then after that,
drop test,
deflection test, permanent set.
Permanent set.
Test conducted, result found within.
So, my lord, possibly not only visual, there were other tests conducted
Whatever test.
also. But I am not saying that they could not have tested somewhere. But now kindly sees what happens. I give the materials in October 2025. Nothing forthcoming from there until June. In June, suddenly, respondent number 3 issues an email saying that I have received an email with 3 attachments. No hearing, no notice, no joint inspection given, no show cause, nothing. Suddenly, this letter comes that I proposed action of debarment. Now, what problem I am suffering? Oh, no. Now, this minute, but I have given the test, the Jadavpur University's report that if the other parameters which your lordship had seen at that page of the test report conform to the requisite criteria, there cannot be any issue with regard to the yield test either. So, whichever way your lordship sees at this, my materials cannot be said to be bad. That is one. 2, blacklisting without any notice, and your lordship is. There are several judgments of your lordships also. I'm also.
No, the notice.
Yes.
Notice is given to you. Why shall not we kindly come to that?
Yes, my lord.
The notice has been issued to you. It's not.
Well, the first one is at 117. At my lord, page 119.
Correct. Further terms of provision shall not be. Further terms of the provision contained under the contract and so applicable conditions however will be defaulting manufacturer.
Shall be liable to be defaulted.
Yes, shall be liable.
This is shall be liable to. So, my lord,
where is the final order? Have you
this is what we got.
Have you given the reply to this?
No, we have not. But what we have given, not reply to this, because this is not issued to me also.
Correct.
This is issued by R1 to R2.
Correct. Because
then, my lord,
because
next page.
It is not directly to you, no?
Not directly to me.
You're also not directly contacted with them.
No.
That's why they have issued the notice to them.
Yes. Now R2 giving to R3 is page, my lord, 120.
R1 is given to R2.
Yes.
And R2 has given to R3.
That is
and
120.
R3 has given to you.
R3 has given to me.
Correct.
Saying relying on the clauses of the other letters.
Correct.
So R3 is not taking any individual step against.
Correct.
So they are saying that by these 2 letters, This is what is being proposed.
This has been done after my representation was.
So, well,
given
I
last
had
court.
given the representation on 9th of
But you
June
cannot conduct
when I
this.
first came to learn that my goods have failed.
115.
That is at page minute
5. 115.
115. But I write to R2 pointing out all these, my lord, your lordship would find in bullets, my lord, at page 115.
And in spite of receiving this, they have not show cause, not given me any.
So no hearing given even after this, my lord, I had given a representation asking for retesting. Nothing done.
But the notice was issued on when?
Yes.
When you received the notice?
Yes, my lord, yes, my lord, your lordship would kindly have a look at.
You have received the notice on 12/6.
Right. My lord, your lordship would kindly have a look at my pleading in paragraph, my lord, 12 at page 5. I was informed by them that your goods have failed. And I went there. There I make a representation that it cannot fail. Call me for a joint inspection. Share the report with me. They keep mum. I receive an email. I make a communication on 9th May. Thereafter, I received an email on 12th.
In spite of this being.
In spite of my representation at page 115, that is not considered. And this mail I receive on 12th. 12th annexure, the attachments are dated 9th. I'm sorry, page 124, paragraph 6.
Yes.
I have been told by the respondent number 3 at paragraph 6 that you take up the matter with RVNL and HPSCBL.
Correct. Whatever it may be, you have received the letter on 12/6. Why you not given submission? Submitted because where is no final order is passed.
They say
where is the final order?
No, this is what we got.
So let you submit the reply. Then if any order is
But
passed, then
I-
only you cannot say the opportunity is not given and notice has been given to you.
This is
You
not
have
been
to submit
given
the
to me.
report.
This
Yes.
is not been given to me.
Not given to you, but you are also not directly connected to one.
I am only connected to 3.
You connected to 3. Correct. So that's why the one has given to 2. 2 has given to 3. 3 has given to you. Then you have to submit the reply. Where is the final report? And what is your allegation?
That report they shared, it said is failed.
Maybe failed. You
So
could
I have given the reply saying
no,
that
no, you are not given the reply to the show cause. You simply stated that retest
but
may
it's
be.
not a show cause, man. If your lordship kindly sees,
Yes.
it's not really a show cause. They have made up their mind.
Okay, let the notice issued. Let them come and say that this is not a so called.
But till such time, let them. Well, otherwise, but if they
Sir, first of all, this is not the final order of blacklisting. Correct. Shall not be debarred. Shall not be debarred is not a blacklisting. It is
But
the
it says shall be debarred.
It
But
is
it
an
says
opportunity to you. You have to give the reply, then they have to pass an order. They have not passed any order. How the on the apprehension the interim order can be passed?
Your lordship kindly see the language once. It
Yes.
possibly does not say shall not.
Yes.
Kindly sees minute at page 119.
124, you come to 124.
But 119, if you would your lordship.
You were concerned with 124. Are we
124, yes, my lord.
124 first paragraph.
Yes, RVNL has also stated that in terms of the provisions of the contract agreement and the applicable conditions of the award, the manufacturer who supplied material has reportedly failed in NABL laboratory testing may be liable for debarment.
Maybe.
Yes.
May be liable. So,
This is R3 saying.
Yeah.
Kindly see what R1 is saying. Page 119, my lord. Kindly see page 119, second paragraph.
yes.
But I'm skipping the first 2 lines. Shall be liable to be debarred. Kindly see the
Shall be-
language.
shall be
be liable.
Huh.
So, my lord, this is perhaps not only, my lord, it's not a shall be liable to be. It's not a
Shall be liable to depend upon supply of registration system as well as the power unit.
shall be liable to be.
Yes.
So, my lord, it's not really a show cause that before debarment. This is the parent authority issuing it to R2. R1 issuing to R2.
So you could have been given the reply. Why you are not given the reply?
Mr. Chaudhary.
Where is the final order?
Kindly clarify, my lord, that without a hearing, no final order will be passed.
I am only issuing the notice. I will record that the notice which you challenge is found that this is only a notice and not a final order. Let the respondent clarify whether this is a final order or is so-called notice. If it is a so-called notice, you have to give the reply.
And one more sentence, Lord, which is the law, and your lordship has already also.
Correct. That's why I'm asking.
Without a hearing, it can't be done.
That's why without a hearing, so they have issued the notice, might be shall or whatever it may be. But there is no, you have been debarred, it is not there. Where is the final order? You tell me the final order, then the court.
No, my lord, if your lordship is right, if this is not constitutive a final order,
Final order.
I can't have a cause of action.
Correct.
But you will clarify that, my lord, I have no issue. And also, my lord, just put in a sentence for protection of the principle that there can't be a final order without a hearing. That, my lord, I think is a fair solution. I can't, my lord, ask for more. Yes, your lordship is right. Lord, please look at 119.
119 and 119.
Yes,
12.
just 119, my lord.
Yes.
Further in the second paragraph, further, in terms of the provisions contained under the contract agreement and applicable conditions of the award, the willful defaulting manufacturer as tabulated above, whose supplied material has failed in NABL laboratory test, shall be liable to be debarred
Correct.
from participation supply for 5 years.
Correct.
Lord, this is not a final order.
Correct.
Now, the other, my lord, document,
124.
124.
First paragraph.
Yes. RVNL has stated that in terms of the provisions of the contract agreement and the applicable conditions of award has failed, may be liable for
May be
debarment.
liable.
So, my lord, only, my lord, thing is, my kindly, my lord, direct notice. And, my lord, if your lordship only records that without a hearing, there can be no fine. If they give me a hearing tomorrow and give a, my lord, because there is no mention that they'll give us a hearing.
No show cause also.
If they give us a hearing and a show cause, we'll go and do it. There's no problem.
Petitioner has filed the present writ application challenging the communications dated 9th of June 2026, wherein the respondent number 1 has issued a letter to the respondent number 2, informing that
I have not directly communicated with him.
informing that Messrs. Rights by letter dated 1st of June 2026 has intimated that the materials as mentioned in the said notice, the materials of the samples as mentioned in the said notice with regard to the steel tubular holes has failed during testing conducted in an NABL as radiated laboratory. In the said notice, it is further mentioned that as per the contract agreement and the applicable conditions, the award conditions of the award, the willful defaulting manufacturer as tabulated above, whose supplied material has failed in NABL laboratory testing, shall be liable to be debarred from the participation, supply, registration, and business dealing in HPSABL as well as the power utilities in the country for the period of 5 years. 5 years. The respondent number 3 has communicated, has sent a communication to the petitioner on 12th of June 2026, informing that RVNL in terms of the provisions of the contract and the applicable conditions of the award, the manufacturer whose supplied material has reportedly failed in NABL laboratory testing may be liable for debarment from participation, supply, registration, and business dealing of RVNL, HPSCBL, and other power utilities across the country from the 5 years. And counsel for the counsel appearing for the petition submit that the respondent on the respondent number 1 has issued the said notice, which was communicated by the respondent number 3 to respondent number 1 without giving an opportunity of hearing by debarring the petitioner's company for 5 years. Considering the submission made by the counsel for the petition and the communication, the impugned communications, this court find that this court find that the said communications are not the final, but the petitioners are apprehending that this is the, as per the language of this communication, is the same or final order. In view of the above, the respondent authorities are directed to clarify whether the communication dated 9th June 2026 and the 12th June 2026 are the final order, or a notice to the petitioner as so cause notice to the petitioner. Full stop. If it is a final order, full stop. If the authorities say that it is a final order, the authorities are directed not to pass any final order without giving any opportunity. Petitioner, let the clarification be filed before this court within 2 weeks. List the matter on 9th of July 2020.
I'm grateful.
Yes. Mr. Chaudhary is running away after sabotaging my matter. But there are no more dates.
In this matter.
That's why I said, but he shouldn't run away now after having sabotaged my matter. But there were not 3 dates fixed, none of which came up. If your lordship would not fix some dates also, after this. Your lordship had given me 3 dates, but I think I'll finish in 1.5 sessions. So instead of 3, your lordship gives me 2. Your lordship has a your lordship has a very tight determination. I understand that. But by now, I'm sure your lordship must have forgotten that there was some Priyambada Devi Birla. Your lordship must have forgotten who the person is by now.
You have too many Birlas to forget.
Though the matter is special fixed today at 3 p.m., but due to paucity of time, matter could not be taken up for hearing. Let the matter appear on 21st, 22nd, and 23rd July 2026 at 3 p.m. 21, 22, 23 July.
I have 10 minutes to make submissions. Mr.
I will take the other matter.
Mr. Mitra was objecting to this. He has not come with his broken hand. 200.
That is going everywhere.
That's why I told my Mr. Mitra before the World Cup, he's got the fracture.
It's not a fracture. That's this guy's. He's got a hard fracture, so he can.
This Michel Platini, she remembers it.
That
Beckenbauer. With a broken hand.
Broken hand.
This guy. Item number 7.
I wanted to go 5 and 6. 345.
345 matter before it gets hijacked. Can we?
5 minutes. Yes. Call. Item number 7. You are appearing. Yes.
I am the petitioner. This is
What is your prayer?
Pardon?
What is your prayer?
Prayer is the loan to be closed.
Which bank?
Indian Bank. Now it is. It was actually Allahabad Bank to start with. Now it is Indian Bank. The loan is no more there. So I need a no due certificate and return of my.
Where is the notice certificate? Where is the document that you have paid the loan?
No, not paid. But the thing is that loan has been waived by conduct.
Where is that?
By conduct.
By
madam.
conduct. By conduct, loan can be waived.
Yes, madam.
How?
Madam, yet. Oh, sorry. The bill. Just a moment, madam.
How by conduct the loan can be waived?
Just a moment, madam. In a judgment of the apex court, my lord,
How much loan you have taken?
16 lakhs, 16.5 lakhs. Yeah, I take.
16.50 lakh.
Yeah.
1995.
1995.
So you have not returned that.
I have paid half of the amount within 2 years, but thereafter I had to stop the repayment. My lord, kindly allow me to state the story. It is a very bizarre and very interesting story. My lord, I am a doctor. I am a pediatrician, to be more precise. But my passion is research, and it's a very bizarre thing, that is medical electronics. Now, my lord, when I entered into the research field, I had to earn some money, so I started organizing a medical diagnostic center so that I can earn something. In 1995, I took a loan from Canara Bank. It was repaid on time. 1990, I took a loan from Punjab National Bank. It was repaid on within 2 years. But the problem arose when I approached Allahabad Bank. In 1992, I approached the Allahabad Bank for a multidisciplinary medical diagnostic center. My lord, during the next 3 years, I became a shuttlecock between branch, region, zone, and head office. Finally, in 1995, I received a loan of 16.5 lakhs term loan.
Correct.
And with 15.5% rate of interest quarterly rest, and 1.25 lakhs of what's that called? That sort of loan, but which I didn't use at all. But after starting repayment, I could find that my loan, instead of being repaid, it is going up. And in 97, 98, I found that my loan has, despite repayment, has gone up to 19 point something lakh, because they were charging 18.5% of interest without any information to me. So I tried to settle it by various methods, like selling of my house and repayment, etc. But everything was refused. So in 1999, I stopped repayment. In 2000, I filed a compensation suit against the bank of 30 lakhs. But at that time, DRT was exclusively meant for, the banks. So I had to institute this compensation suit before the Learned City Civil Court. In 2001, this was 2000. In 2001, the bank filed a retaliatory recovery suit of 32 lakhs, much over invoice.
Against you? Against you?
Against me, in DRT. Well,
the suit was transferred to the DRT.
That was the suit they directly.
Correct. That was transferred to the DRT.
That 2000 compensation suit was transferred to DRT in 2005.
Correct.
Now, 2002, I tried to settle it through Lok Adalat, but they refused. 2003, something happened. My lord, there was an OTA scheme of.
So now the matter is pending before the DRT.
DRT has been pending for 25 years.
Correct. So what do you want here?
Because they are not working.
Pendency of the DRT matter. How the writ court can this court can entertain your writ application?
Because there is non-prosecution during last 15 years.
Non-prosecution of?
Who
bank filed the DRT? Who has filed the suit before the DRT?
The bank filed the suit, and last 15 years they don't have any.
So where is the application for dismissal of the suit? Bank is not appearing. Where is the application?
Yeah, I filed an interlocutory application for dismissal of the OA.
Oh, yeah, you filed the OA along.
And that is also 6 years old, and they are not listening to it. I
What do you
went to
want
DRAT. I went
What do you
to
want from this court?
I went to DRAT, my lord.
Ah.
DRAT passed an order in August 2023 to complete the matter within 3 months. Now it is 2.5 years there.
Correct.
With
So
23
the
adjournments.
Last on 13 November 2025, the matter was fixed before the DRT. What has happened? November 2025?
Nothing. 23 adjournments, my lord. During 2.5 years, they are taking.
Disposing it, directing the DRT to dispose of the OA.
They are not doing.
The application within.
They are not doing. They are not doing anything.
I am directing, disposing of this. What can be done now? Further, this court cannot pass any order pending of the original application before the DRT, sir. That is the problem. Law does
But
not
if they
provide.
don't do it, then
Yes.
if they don't do it,
don't do it, then you have. That's why I am passing an order directing the DRT to dispose
the
of your.
DRAT has already passed an order.
Where is disposed of?
Yes, to dispose it off within 3 months.
Where is that?
That is
Where is the DRAT order?
DRAT order is my lord, 81, page 81. They have instructed to complete the dispose of the matter within 3 months. And since then, they have taken 23 adjournments.
What is the order dated 19th February? And advocate census appeal for the applicant bank appeal to complaint census.
In 19th February, my lord, DRT passed an order to hold that adjudication.
You, the ex party was
ex party.
Okay.
When I was there.
So okay, I am disposing of this, directing the DRT.
Nothing will happen, my lord.
So what can be done? This court cannot take jurisdiction of the DRT. This court cannot pass any order in the writ petition.
So, my lord, DRAT has said that.
Yes, I will record that also. If it is not, then you come before this court. The only grievance of the petitioner that the proceeding is pending before the DRT
25 years, my lord.
Since the year 2020. The appellate tribunal by an order dated 17th of August 2023 has also directed the DRT and DRT to conclude the proceeding and decide the same within a period of 3 months from the date of copy of the order. But in spite of the said order passed by the DAR, the appellate authority, the DRT has not disposed of the original application original application number 137 of 2001. Considering the above, this could find that the only grievance of the petitioner that for the last 25 years the matter is pending before the DRT. In spite of the order passed by the appellate authority, also the DRT has not disposed of the original application. In view of the above, the DRT is directed. DRT 1, DRT 2.
DRT 1.
DRT
My lord, kindly time bound, my lord.
DRT 1 Kolkata bench is directed to dispose of the OA number 137 of 2001 along with all connected application, if any, within a period of 6 months from the date of receipt of this order.
My lord, bit shorter time.
6 months.
25 years, my lord, already.
Yes, next. Dispose of WPA number.
And my lord, kindly, if they do not do anything within 6 months, then I may come over here. My lord.
6 months.
Number 5 and 6, at 6:45.
Yes, what else?
Next matter, my lord.
Fixed matter.
Heard partially, my lord, one day and then my lord it got 8.
Let us see. Yes, next.
Yeah.
Argument.
I appear for the defendant. Your lordship was hearing, defendant number 1.
Yes.
Is that bank suit. Second round of litigation, as it were. Where's the other? Me too.
My lord, I am appearing for bank, my lord.
Yes.
So your lordship also has it fixed at I think 3 p.m. or day after tomorrow. I should finish because on the last week's one we missed. Your lordship was hearing matters of state, so we couldn't get there. Anyway, well, I've submitted for 3 days. In the days would be an exaggeration, my lord. 3 sets of 15 to half an hour, whatever. First day I placed the pleadings, the plaint and the written statement. My lord will just only once I'll take my lord back. The plaint prayer A. If my lord sees prayer A of the plaint. So today I intend to just recap the whole thing as briefly as possible so that I can just show my lord the evidence and complete on the next day. Prayer A is a declaration that the plaintiff, that was the bank, was entitled to exercise its lien and adjust and or set off the fixed deposit proceeds against the dues of and or claims against SL Settle Liners and Drum Place Limited and had rightfully and validly made such adjustment. So now your lordship may recall Drum Place Limited is the decree they have obtained and they showed the division bench.
Yes.
And that decree they have admittedly not adjusted this amount against this decree. Even though this is the only reason they got the leave in the earlier suit. So first day I just cited the
so this is the suit of the bank.
Bank suit. In 90, I'll tell my lord very briefly the facts. So first day I had placed the pleading and the plaint and the written statement.
Yes.
We had the defendant number 1 had given an FD in 1984 November. Well, then it 6 months expired. We asked for the money back. The bank said, no, we have a lien over this. And all they had to show in evidence is there's a letter from an advocate in the UK which says that RK agency has allotted 20 million rupees to be sent. Now, this is to be sent to a foreigner's account, not even to the bank. It's supposed to be sent to that foreigner. That foreigner will pay off the bank. This is their case. But all this is subject to RBI permission. This RBI permission was not got in 6 months, admittedly. I asked for my money back. That was a transaction would have been over. So they don't give my money back. So then from May 1985, right up to before we filed the suit, we made demands, etc. In the meantime, the bank applied for permission. And this they didn't, they suppressed before the court initially. It's come out later in the evidence. They applied for permission and it was refused. So the RBI refused the permission. So the story was over. If there was a contractual lien, if I had even agreed, which they haven't proved, that I will pay this money to someone else, it was subject to getting approval, which was never got. So that would be the end of the story, one would have thought. But what happened was because they had complained to the RBI and RBI said no, permission is not required, RBI started an investigation and they blocked this account. And they said that you mustn't close this account till the investigation is over. Now, this investigation went on from 1986 to 2006. And then they said they found nothing, they released it. So the second game that the bank played was up to 2006. They said that since the account was blocked, no interest had accrued. So the initial, I invested 20 lakhs, I would have got 20 lakhs, 60,000 in May 85. So and then they told the court, while the suit, by that time I had filed a suit for return of my money, they tell the court, we have adjusted 20 lakhs 60,000 against the dues of a foreign company, whose account has now been transferred to India, so we don't need permission. Again, two misstatements, my lord. One is that there was no transfer of account. Now it appears that the bank itself, central bank, was thrown out of UK in 1986, December 1986. And the banking transaction had stopped. So their accounts were transferred here, but not the accounts of the parties. These were all written off in the UK itself as it falls. So there was no transfer, number one. Number two, when they filed this suit, they inadvertently or deliberately, they disclosed some new documents in which it shows that more than 1 crore of rupees had accrued. And they had purported to adjust this, but they suppressed that fact. So my interest went, and it was a compound interest, obviously. So these two facts were unknown to the court in the earlier suit. Earlier suit, I've simply got a decree. Yes, there is no lien. There is no permission of the Reserve Bank. They could not have been a lien. Return his money with simple interest. And because it was thought that there was no interest had accrued in the meantime. Whereas, according to the bank, retrospectively, they are saying that we gave compound interest. But according to us, this was all done as a afterthought, and the money had already been appropriated in 85. And that is why I have a counterclaim also that the money that they have profited from my account, which is at compound interest, and I have proved all the rates through the bank's witness, prime lending rate, 4% extra, etc. So we have made a calculation for this. So as far as, let me go at one thing at a time. Lien. I told my lord we had had a short discussion. What is a lien? It's a retention of something, usually. Now there can be two types of lien. One is a contractual lien. Let us talk about here. They say that as per the letter of the advocate in the solicitor in UK, we had promised to send 20 million rupees, that's 20 lakhs, to UK, subject to permission. So then when the division bench observes, when they show that no, we had a decree against them, they promised to pay, etc., the division bench says that yes, even if there was a lien, but it has been frustrated because there's no permission. It's a contingent contract. We could not have sent the money abroad. So that was the end of the contractual lien. Now, it could be argued, though they haven't argued, that a bank, after all, I'm a bank under 171 of the Contracts Act, they have a general lien on my account. But then they would have had to show that defendant number one, RK agency owed them a debt. They have admitted, I have never taken a loan from them. I've got no monies due to them. Therefore, only my debt could have been adjusted against a balance if it was in my account. But here, that also did not happen. So this basically prayer A is a non-starter. And in the prayer itself, it says claims against SL Setia and drum place. Whereas now they've come up with a specific case in the profit and loss account, it was adjusted against SL Setia Liners Limited. So if
other than that letter of the advocate, there is no other order
no,
of,
no, but we have disclosed the plaint. They had filed a suit against SL Setia. SL Setia Liners, it turns out from the bank's letters itself, has been wound up in England. Drum Place has also been wound up. The decree was executed against Drum Place and wound up. But even after that, they come to the division bench at the last day of the hearing and say, we have a Queen's Bench decree. I placed that division bench order in detail. First day I placed the pleading, second day I placed the 3 judgments. And so if this prayer goes, well, the next prayer goes automatically. Decree for perpetual injunction.
Unless the first is not been declared, then...
Yes, so this doesn't come and they haven't challenged the decree. That is why the first glance, also your lordship felt that decree is standing. Now the money that I'm going to get in the decree, they have attached, so to speak, by depositing the equivalent amount before this court. So they are saying you are secure. But the fact is, from 1985, I've not got my money back. The interest which the bank will have got is, now we'll come to our counterclaim. I'm giving a very quick summary. I'm sorry. In the counterclaim, that is why the history of this 40 years litigation is important, because the counterclaim we are trying to show that the bank has deliberately, abuse of process of court, misled the court, and I have not got my dues. There are several things. One was there was no transfer of account. They've said categorically the transfer. I'll show the pleadings. Secondly, there was no decree against SL Setia Liners. They write, I have a decree against SL Setia Liners. Now, 20 years later, the bank manager goes in, he says, no, I have not seen the records. I don't know about it. So he equivocates again. So, and then thirdly, they say, we couldn't give them interest because there was a blocking order. And it appears that they have been giving interest at a compound rate. So what would be my remedy? One would be that, of course, I get my money back. If these misrepresentations weren't made, I would get at least compound interest in my earlier suit. But these facts were suppressed from the court. I've got simple interest.
So what you prayed in the counterclaim?
We have assessed punitive damages at 40 crores, but that also it will be more. So I'm saying that there are 2 ways I can assess it. One is that simple thing that I had made a fixed deposit, you enjoyed compound interest on it. If you could have paid compound interest on it till today, then I would have got, it's coming to about 23 crores. But the claim I've made in the counterclaim, I'll come to that. I placed the pleadings, I'll come to that, the details. What we are going to argue before my lord, and what from the evidence, what I've tried to prove is that the bank was unjustly enriched by keeping this money for so long. So even if you take away the fact that they'll give me back my principal after 40 years, they have to disgorge the money they have earned. And if they were, and I asked this to the bank manager himself, and he himself has disclosed the RBI rates and the prime lending rates. It comes to an embarrassing 123 crores. So, but then your lordship will have to decide between 23 crores and 123 crores. That is the, and I'll try to justify at least the fact that.
So you, as per your counterclaim, no, you are only interest and the compounding.
Not, if I say interest, I'll be hit by res judicata because I've got interest. Simple interest I've got. Now, these are facts that have come to our knowledge after the filing of this suit, that the fact that there was no blocking by the RBI of the interest on that account, and they could not have. RBI is not interested in the money. It was only to see, was this money legally
So in
procured.
your original suit, you got the amount and the interest. As per
They said
paper.
they said 20 lakhs, 60,000 interest I got, and from that date of decree, I'm getting on 20 lakhs 60,000.
Correct.
Whereas they had actually in 2000, the decree came in 2012, I think. In 2006, now it appears 1 crore 10 lakhs had already accrued in 2006 when they allegedly appropriated the money. So my interest would have been minimum 1 crore more in that sense. And if that's compounded.
No, what was the decree?
Yes, the decree was 20 crores, 20 lakhs. I think 28,000 was the principal amount, and I'm getting 12% interest.
From
Simple
86.
interest. From that 6 months when the day, 85.
85.
Once it matured from that day.
So you got the interest of 15%.
No, 8%, 11%. 11%. And now that money, after now about 1 crore 29 has been deposited when they filed this suit. And that is whatever interest is accruing, I'll get that money. So that will be adjusted if at all, if I get a counterclaim. Obviously, your lordship will give credit for that. But right now, really what I'm suffering is this suit was filed in 2017, and still now I have not enjoyed the decree. It's there in the bank, in the court.
So compensation. So you are paying for the compensation.
Yes, in the sense that I am not getting what I would have got if that money was with me, number one. And this money would have been with me, but for this litigation. In 2017, at least I would have got my money, what is for all it's worth, and invested it. But this, so they haven't even challenged the decree. So that is the most subtle part of the case, which the plaintiff will have to explain to my lord, that what leave did they get from the division bench? Because they gave the impression to the division bench, and this is my submission, they'll give their own interpretation, that we have a decree, and the judge felt, okay, you have a decree, you can take steps to
Queen's bench judgment.
Division bench judgment.
No. They are relying upon the decree of the Queen's bench earlier.
Yes, they had shown, but Queen's bench decrees against drum plays.
Not by
No, now what happens is immediately after the division bench order, they realize they managed to get a leeway through drum plays, but they are saying they've adjusted it against SL Setia liners. They filed this to the Supreme Court. On one page, if I may show my lord, volume 5, page 700. I forgot to show this. I had shown the other grounds in the SLP. Just they stand before the Supreme Court, volume 5, page 700. Arekta part of the synopsis of this. What is volume 5. First, my lord will come to page 700. I've forgotten to show this.
700?
Yes. This is the list of dates when they, after the division bench order, they went up on appeal. Then the list of dates, their first entry at 1984-85. Drum Place Limited and SL Setia Liners Limited, both belonging to the House of Setia group of companies. Well, this was a new entity they have made up. be that as it may, jointly owed so much money to the bank. The petitioner bank has taken civil action against both the companies in England, in the English courts, in addition to criminal complaint against Drum Place. The suits against Drum Place and SL Setia were decreed in the petitioner's favor, and during execution proceedings, Drum Place was ordered to be wound up. So this they knew when they were filing this appeal in 2012, they knew that they have no recourse against Drum Place, even though they obtained that order showing the Drum Place decree. So now they've said that it was decreed against SL Setia liners. And till today, they have not managed to show that. And what did they really appeal against? If my lord comes back 2 pages, 698. They wanted to say
whether
the present petition, synopsis, the present petition is limited to the question whether the petitioner's right of set off and adjustment, set off stroke adjust the deposit lying with it towards the outstanding debt is contingent upon the permission of RBI. Because Justice Oshim Banerjee in the division bench judgment said that yes, there could be a nexus between your fixed deposit and the debt of somebody else. They are now saying that no, this is a nexus that Setia's owned everything. That was not the contention. There was a nexus between your fixed deposit, which the solicitor had said will be sent to England. But this nexus is contingent on the RBI permission, which was never got, and it was frustrating. So that finding is very clear that it is a contingent contract, and that is finalized. And so that is why they went on appeal, and they said the only question is the right of set off contingent upon permission? And then the usual equivocal pleading in the list of dates that they have a decree against both.
So now the main question with regard to that was a lien or the reserve, that permission was not required.
Yes,
because as per this.
Yes, that's what they tried to say, but they lost before the Supreme Court.
Correct.
So what are they arguing now? Unfortunately, I have had to start the argument because my witness went last. My argument would have perhaps been shorter if I knew what they would argue.
Yes, next.
Now, the Supreme Court order I showed, my lord. Page 1 of this volume. I had shown my lord the Supreme Court.
Yes.
I won't. And just before I go back to the pleadings and evidence, my lord, page 575, if my lord sees the pleading before the division bench in volume 4. You know, I'm reading out the Supreme Court order. It's 2 lines, my lord. It's page 1, first volume. 575, I want to show, my lord, before since the division bench, ground 23. I think I'd shown this.
That's so now you've taken note of it.
For the rate of interest, they are saying that it's not tenable because we are not bound to pay any amount. And today it's come out manifold. They have been paying. The interest has been accruing, and they had already 1 crore 10 lakhs in 2006. So if that amount is simply compounded, that is the amount I'm losing today. I'm getting my decretal amount, I hope.
The amount which you deposit, that is, you're sure it is in the fixed deposit?
Yes, in the court. We had taken a certificate.
Fixed deposit or lying in the?
No, it's fixed deposit. I'm sure. In fact, it's getting a good return. So, yes. So my main idea today was to just tell my lord this. Then I want to take one by one, my lord through the incorrect or contradictory or inconsistent submissions. I don't want to say deceptive, but that is what we are trying to say, because we have prepared a full list of days. I was thinking I'll give it on day after tomorrow because it's 3 o'clock. I'll have that 45 minutes. I'll place the list of dates and I'll show how I've calculated my theme. Now, what we have done, we've also made an analysis of the various contradictions that were there. Now, I've shown my lord 2 of them just now. Where's the note? I've lost my, there's some sort. So I've shown my lord that there was no, my submission is there is no decree against SL Satya Liners Limited. Now, when I confronted the witness, he said, I don't know about it. So, but they have admittedly not produced any decree against this
SL Satya.
this company, and therefore, at least the pleadings and the representations they made were wrong. Now, in the prayer A, they've said against the dues of. Now they have had to prove what the dues are. They merely said that the account of SL Satya Liners was written off in London, and the profit and loss account has been transferred to India, and therefore we don't need any permission. But that is incorrect, because for any foreigner's account, I think I'd shown the provision. FERA. There's a practice. Well, it's there. I'll just show this thing. Annex A. Well, it's in the paper book. I'll give my lord the page number. I'm just reading out this Regulation 3. In terms of Regulation 3 of the Foreign Exchange Management Regulations 2000, use of a fixed deposit of an Indian company as lien or guarantee to secure or redeem or set off the liability of a foreign company is permitted only with the prior permission of the Reserve Bank of India. Regulation 3. Well, the book they haven't got today, I'll give that. So they could not have, under any circumstances, my lord, said that no permission is required. That is first my submission. Second submission is they argued this before the Supreme Court, and the Supreme Court did not interfere with the SLP at all. And I'm reading out this page 2, volume 1 is the Supreme Court order. Page 1, in fact, it starts. Page 1 is just the names. Page 2, the usual order. We do not see any ground to interfere with the impugned order. Special leave is dismissed, accordingly dismissed. And the time of 6 months stipulated is extended. They were given 6 months to file appropriate proceedings. Now, whether this is that appropriate proceedings or not is the question. We are saying this is not appropriate because we are asking for the same thing. This fixed deposit matured. I am to get it's been adjudicated for 20 years. I am to get the proceeds of this fixed deposit. Now you're saying, no, this fixed deposit, I had already adjusted against someone else. So if they are correct in this suit, it undoes my first suit totally. I could have understood what they represented before the division bench was, I have a decree. I want to adjust this money. I get a decree for 20 lakhs. That money is attached till this decree is adjudicated. That doesn't happen. So there's no decree, number one. Then the decree against Drum Place is not being executed. That is the one they had shown. And in the Supreme Court itself, they have gone on to say that, no, we also have a decree against SL Satya Liners. Next is they had suppressed the accruing of interest. That I've shown, my lord, that they had pleaded in that before the division bench that no, and there is also instances when I showed the deposition, I'll put it in my list of dates itself. Their manager has said no interest has accrued. How can it accrue? The bank has given a blocking order. RBI has given. This RBI blocking order came in 1986 sometime. My fixed deposit matured in 85. They gave no excuse why from 85 to 86, when they kept referring me to their international division, and why they didn't give us this, give this back at that time, because there was no blocking order at that time. Anyway, they suppressed the second manifold, which I've shown, my lord. Then this witness statement was made. Now, as far as the RBI permission is concerned, admittedly, the plaintiff never took the permission. Now, the fact that they took permission also was suppressed by, when I first filed the suit in 1987, we filed an application under Chapter 13A. And in the opposition, they suppressed the fact that they had taken permission. Then the learned judge subpoenaed the RBI and asked for the records. And when the records came, it turned out RBI had refused the permission. So that also came out through our efforts, as it were. Ultimately, because of this, the Chapter 13A decree was set aside because it was said that without taking evidence, you shouldn't have called for new documents. It was a question of trial. So, but that judgment came. Our court is like, it looks embarrassing when we are arguing it 40 years later. But we got the decree in 87, and then the appeal was in 2004. Then after the appeal, then the whole matter was reheard before the trial court. The suit was heard out, and ultimately 2012, we got this decree. Then, so Chapter 13A was suppressed. That's another one of the, because of their actions. Now, without this permission, there can be no lien. That is my fundamental submission. Whether you call it contractual lien, that has actually been decided. There could have been no lien by the division bench and by Justice Maharaj Sinha, as he then was, my lord, the trial court. Then, besides that, we have taken a lot of pain, my lord, giving the evidence. We have pointed out every time that they made a shifting stand. Who is this foreigner? To whose account? Because the document says we will send this money to a foreigner's account. Sometimes it's Drum Place, sometimes it's SL Setia Liners. Later, it was the Setia group of companies. I asked the banker that, is there an account in the name of a Setia group? He said, no, you can't have an account in the name of a group. It has to be in the name of a person. Then the foreigner was doubtful. The fact that the bank account had been closed and written off in England was suppressed. They told the court, we have transferred the account to India. Now it's no longer a foreign account. We don't need permission. And therefore, in 2006, during the pendency of a suit, evidence was going on, they transferred the money. So basic, my conclusion, I wanted to be short today, that basic thing is, where is the adjudication of this debt? This whether SL Setia Liners owed them money or not is a question in doubt, because there's no adjudication. And then I will place that on first thing on the next day, Malak. There are 2 letters by the solicitor in London of SL Setia Liners Limited. That was not my solicitor, not his solicitor. They wrote that when the bank had made a claim against SL Setia Liners, RK agencies had agreed to send 20 lakhs of rupees. So one paragraph of the letter, the bank proves and says, I want to have nothing to do with the rest of the letter. The rest of the letter is very interesting because the solicitors of the bank, Malad, had written to, after this letter, wrote to Zaiwala and said that there is no such arrangement. There is no, we are not agreeing that 20 lakhs is going to be paid by someone else. There is no such arrangement. And the 17 July, just this letter I'll show my today. That Zaiwala then writes back to them. By this time, the solicitor of the bank had changed. He said, we are shocked and appalled at the stand you've taken that there is no arrangement. So on the face of the documents itself, this arrangement had been given a go-by, 17th of July. Volume 1, my lord. I'll just take my page. I'll just. July. Zaiwala's letter. Page 14. 1-4. Yes. Page 14, Mano. This is the second letter of Zaiwala. Yes. My lord comes to page 15, the last paragraph. With regard to the deposit of rupees 2 million with your client's Calcutta branch, your client is writing to the bank's Calcutta branch. Our clients are simply appalled that your clients, by acknowledging the receipt of 2 million rupees from our client solicitors, Khanna, should plead ignorance of the fact that these monies were deposited on our client's behalf. So they have denied it. If your clients now wish to ignore the deposits placed with them by our Messrs. RK agencies on our client's behalf through Khanna, then our clients have asked you to take instructions from your client and confirm that the bank will allow our RK agencies to withdraw this deposit on demand. So they say that you are yourself is saying that this arrangement is not there. You please allow them to take it back.
Yes.
This was all, I won't say it's completely fictitious, but it was all, it was in a planning stage. And there's no, and then the bank comes now in this suit, and even in the earlier suit, they try to say that no, the Satyas are behind all this. There are many Satyas. There's a father, uncle, son, everybody is there. No one is denying that. But my lord, the nexus that RK agencies is owned, is the same alter ego of SL Satya Liners. No attempt has been made to prove, and it's not true, because there's a separate private company in England, there's a separate company here, no common directors. They might be, the surnames might be same, they might be family members, but that is not the nexus that uncle has to pay the debts of a nephew, of another. So, or other way around, RK agencies doesn't have to pay the debt. An arrangement was sought that didn't work out. The law doesn't permit it. I read that out. The lien or guarantee cannot be done without RBI permission. And that is clearly what the division bench has made a finding. Clearly, that is what they appealed from. They lost. But they went back, and because of this leave given, and they managed to stall the execution of the decree. So I think the main points of my argument, I have succeeded in doing. I will take my lord once through the list of dates. There are about, we've tabulated about 10 discrepancies made at 10 different stages of the litigation. That's one thing I'll try to explain on the next day. And I'll quickly take my lord through the actors or the protagonists, as it were, who is RK agencies, who is SL Satya Liners, who is drum plays, what was the role of the central bank, what was the role of Reserve Bank. And then I should be able to sum up. And my counterclaim, again, I'm reiterating, my lord, that it is based purely on this calculation, is what is the loss, that how the loss can be calculated if, or what is the damages that I'm entitled to if these misrepresentations turn out to be true. Is there no recourse that someone would do this? In fact, Justice Maharaj Sinha in his decree observed that if all the banks start doing this and denying that they, in spite of any adjudication of the claim saying that no, this money I'm appropriating for a third party's debt, then it would be a very sad state of affairs. That's what the comment was done. So therefore, it cannot be that the bank can get away without compensating me in some way or the other. I cannot simply ask for interest because I'd asked for interest in the earlier suit. I'd asked for compound interest. They came and gave evidence that it's been blocked, and the bank took that at face value. So now that compound interest for sure I lost. But also the fact that they have gained what unlawful, like mean profits, what they have gained from withholding this money, if it is held. Already 3 rounds it has been held, it's been wrongfully withheld. But if it is again held that it's wrongfully withheld, they have to pay. And if not to us, at least to some organization. My client has said that also, that if not that way.
Okay.
So I'll come back with the counterclaim on the next day and a full list of dates for this. Thanks.
Counsel for the defendant argued the matter and due to paucity of time, hearing could not be completed. The matter is already fixed on 24th at 3 p.m.
Because, will my lord be kind enough to book, can we fix another date? Because now once the ball is in my learned friend's court, they will say, we have just been briefed new. So at least they should know at least when the next date is going to come. If I finish on the next.
Come on that day.
Any other day.
Come on that day, then I fix. You will complete on that day.
I want to hear the bank mainly. 8th. 10th. 8th. Also.
3:45.
3.
8th 3, huh?
How about 3:45?
And 8 July 3:45 p.m.
Very good. 8th and 10th. Whichever. The lordship keeps it, then it. If I don't finish, I will definitely be there whenever your lordship says. I want to finish now.
না না আমি বলছি আজকে তো আর তো বলবার কিছু নেই। Grateful.
Item number 8. Looking for the respondent for
And for the petitioner.
I think for not today, your lordship, the counsel, he is not there, he had to rush to the hospital.
Your lordship, may kindly be pleased to fix this matter because we had filed this in March and I'm being led by Mr. Banerjee in this matter. He asked me to
Not
kindly
today,
say
come
that
tomorrow. Come tomorrow.
may kindly retain its position in the list. Grateful.